Hello, everyone, and welcome to the first day of the Counseling Compact Legislative Summit, hosted by the Council of State Governments National Center for Interstate Compacts. My name is Andrew Bates, and I will be your host for today's session. I'm a staffer here with the National Center, where I work on several interstate licensure compacts and also contribute to CSG's Occupational Licensure Policy Project. A bit about CSG. We're a membership organization for states. Each state is a member, every state pays dues. We provide technical assistance and research on best practices and innovative policy solutions to a wide variety of state and federal agencies. Through the CSG National Center for Interstate Compacts, we support states and professions in the development and enactment of interstate compacts to address license portability challenges. We are thrilled to have you here to learn more about the Counseling Compact, an important initiative to increase interstate mobility for professional counselors, with the goal of increasing access to professional counseling services. We want to extend a special welcome to the legislators, regulators, and other state staff that are joining us today, as well as to our friends in the counseling profession, a critically important and growing sector in the mental health field. I'm happy to be joined today by two of the nation's leading experts on interstate compacts, Dan Logsdon, the director of the National Center for Interstate Compacts here at CSG, as well as Nahali Freeland-Kalfas, who serves as legal consultant for NCIC and provides legal services for several interstate compacts and licensure boards. I may defer to the two of them from time to time, so I wanted to introduce them in advance. Before we get started here in earnest, we have a couple quick housekeeping notes. Audience members are welcome to turn their webcams on or off as they are comfortable, but everyone, please keep your mic muted at all times unless speaking. We do want this to be an interactive session, but to the extent possible, we will be holding questions until the end of each individual segment. So each panelist's portion. Feel free to use the chat function to ask a question at any time, but be sure to direct it to everyone so that folks can see what's being asked. Using the raise hand feature on Zoom is also perfectly fine. And please keep in mind that we will have ample time reserved at the end of the session for a more thorough Q&A with our panel. So if your question is pretty complex or if it's directed to multiple panelists, please consider holding it until the very end. If you ask a question, please do identify yourself as well as your state and what organization you're with. And finally, this session is being recorded. So by remaining on the call, you are giving your implied consent to the recording. And also, just to give you an idea of the run of show, I will start us off with a Compacts 101, which is an introduction to the theory and legal basis and current status of interstate licensure compacts. Nahali will then lead a deep dive into the Counseling Compact, the actual model legislation, and we'll answer your more technical questions about the compact. And then we'll hear from the American Association of State Counseling Boards, from members of the counseling profession, and also from individuals involved in the enactment of the counseling compacts in Georgia and Maryland. Given the length, we will have several 5 to 10 minute breaks throughout. And yeah, I would emphasize once again that both days are the same. So if you are attending today, you do not need to attend tomorrow. Once again, really appreciate you joining us. And without further ado, we can get started. So what is an interstate compact? Essentially, an interstate compact is a contract enacted, adopted by states to address a particular policy issue. These can be bilateral between two states, they can be regional, or they can be national in scope. An easy example of an interstate compact is that is national in scope is likely sitting in your wallet or your purse right now, and that's your driver's license. Driver's licenses are not something that the federal government dictated to the states. Instead, the states came together to figure out how residents would be able to drive in other states and how to coordinate that activity. And the result was a mutual recognition model that allows folks to drive in other states by virtue of their home state driver's license. When it comes to interstate cooperation, a compact is the most powerful tool available to states. It is fully binding, it is enforceable in court, and a state can only join a compact by enacting its terms into statute, and likewise can only withdraw from a compact by repealing that same statute. We will get into the structure of a compact a bit later, but in general, a compact creates an interstate commission composed of member state officials to regulate the policy issue in question, allowing states to respond to regional, or in the case of the Counseling Compact, national priorities with a united voice. Crucially, compacts allow states to retain sovereignty over issues belonging to the states. Here at CSG, we would never use terms like states' rights, but we do recognize that there are a limited set of issues on which states absolutely should retain authority, and professional regulation is definitely one of those issues. So compacts have been around really since the founding of the Republic. There was a provision for compacts in the Articles of Confederation, and there's also a compacts clause in the Constitution. Historically, the main uses for interstate compacts have been to resolve boundary disputes and manage access to shared natural resources like waterways. But in more recent years, states have used compacts to create special administrative agencies with jurisdiction over a wide variety of issues that fall under the regulatory purview of states. A famous example of one of these regulatory compacts is the Port Authority of New York and New Jersey, which was founded in 1922 and is now a $9 billion plus agency with more than 7,000 employees. The Port Authority was followed about a decade later in the 1930s by the Colorado River Compact, in which states came together to reach an agreement on the shared use of that critical waterway. After the Colorado River Compact, states were really off and running with these compacts, and today states use compacts to cooperatively regulate dozens of issues, including transportation, taxation, education, and of course, occupational licensure. We have interstate compacts for transportation of juvenile offenders, foster care, military children's education, and even low-level nuclear waste. And in the past couple of decades, we've seen states use compacts to facilitate interstate occupational licensing, beginning with the Nurse Licensure Compact around the turn of the millennium, and now expanding to, going on a dozen professions now with the compacts currently under development. So as I mentioned, there's a compacts clause in the Constitution, which you'll find here. It actually is a bit confusing because it sounds like it's saying no state shall enact a compact, but the Supreme Court has held that consent is only required from Congress if the compact infringes on federal supremacy. So occupational licensure compacts do not whatsoever infringe on federal supremacy, so they don't require the consent of Congress. So today we have over 200 active interstate compacts, including bilateral, regional, and national agreements. We often hear folks say that they're not sure if their state would enact something like this due to issues around sovereignty, et cetera. But as we see here, on average, states are members of about 24 interstate compacts. There are 5 national interstate compacts: the Interstate Juvenile Compact, the Compact for Adult Offender Supervision, the Military Children's Compact, the Interstate Compact for the Placement of Foster Children, and the Emergency Management Assistance Compact. So all states can and have joined these interstate compacts. There is also precedent for international participation, as we see mainly with the firefighting compacts out west and in the Northeast as well, where you have some Canadian provinces that have signed on. And so interstate compacts are definitely not a recent development. They have a history nearly as long as the Republic, and CSG has taken on the task of educating states about these powerful agreements, which is the reason that we founded the National Center back in 2004. And here's just a map showing state compact membership. As you can see, every state, including the District of Columbia, has enacted at least 20 interstate compacts, and some, as many as 30 to 40. So what drives state interest in occupational licensure compacts? Well, there's several reasons, but one is, the looming threat of federal intervention. And so CSG is part of 2 large federal grants from the Department of Labor, where we work with the National Conference of State Legislatures and the National Governors Association to examine occupational licensure policy in the states. For years, the federal government has been asking some very tough questions of states regarding their occupational licensure systems, questions about accessibility, competition, and more. And while there are good answers to all of those questions, The states may not have had those answers ready when the federal government has come knocking. So we continue to see the threat of federal action on occupational licensing. In fact, earlier this year, President Biden issued an executive order that mentioned occupational licensing specifically as an area of concern within the administration's labor and workforce agenda. And we have seen federal legislation introduced in recent years to remove occupational licensing authority from the states, an issue that is clearly, again, within their purview. So as much as ever, the threat of federal intervention is real. We've also seen advances in technology, especially around telehealth, which became a hot button issue during the COVID pandemic due to travel restrictions and social distancing requirements leading to shortages of healthcare practitioners. Something not everyone might realize about telehealth is that the practice is technically taking place in the state where the patient is located. So to practice via telehealth in another state, practitioners need to have a license or a special authorization for that state. Interstate compacts solve the problem by allowing for rapid verification of eligibility to practice in another state, including via telehealth, which we view as just another modality of practice. Licensure compacts use a variety of mechanisms, including expedited licensure in the case of the medical licensure compact, a multi-state license, like a driver's license in the case of the nurse licensure compact, and a privilege to practice, which is the case of the counseling compact and several others, but more on that later. So the benefits of the interstate compacts. So there are several reasons, again, why states are interested in these powerful documents, but here we have some of the top ones. So you have the efficiency of compacts because they create economies of scale. A collective solution to many policy issues is more efficient and more streamlined than a piecemeal approach or state-by-state approach. In occupational licensing, we see this with the greater efficiency of licensure compacts as compared to individual reciprocity agreements that states might sign with one another, or even as compared to the individual universal recognition laws that states have been passing in recent years. Compacts breed uniformity, clarity, and efficiency in the interstate regulation of licensed professions. So flexibility and autonomy, as we mentioned, the threat of federal intervention is very real. And federal policy can't always take into consideration all of the quirks and nuances of particular states or adapt to how a particular state might approach an issue. Compacts create a forum for states via their delegates to the Compact Commission to negotiate and eventually come to a workable agreement on these issues that do account for their differences and unique features. So you have dispute resolution, which is related to the previous, but the forum that is provided by a compact also allows states to resolve any conflicts that might arise without having to pursue any costly or contentious, unfriendly litigation. So you have state and federal partnership. Some compacts, mainly environmental compacts, including the Columbia River Gorge Commission, where our friend and CSG colleague, Jeff Litwack, is actually the counsel. Some compacts allow for representation of federal agencies on the Compact Commission. This facilitates cooperation and communication in the spirit of federalism, which is, of course, a key pillar of American democracy. And lastly, cooperative behaviors. These licensure compacts often become a platform for licensing boards and professional associations to really come together and hash out issues in a more proactive and cohesive manner, rather than adversarial. All of these licensure compacts have the ultimate goal of becoming national in scope, which we define as 45 or more states. And you really do see these compacts turn into a sort of forum for the advancement of sound licensing policy and to drive uniformity in professions, which really benefits everyone at the table. So some more benefits that apply specifically to occupational licensure compacts. As I mentioned, you have agreement on uniform licensure requirements. Compacts do thrive on uniformity, and the standard feature of licensure compacts is that states come together via the commission to agree on what specific standards are necessary to facilitate safe borderless practice in the profession. So focusing on the standards that really do relate to public safety. By its rulemaking authority, the commission is able to make adjustments to these uniform requirements to reflect any changes in the profession and changing priorities of states. But again, the commission is composed of member state officials, so the commission is directly accountable to the member states in the exercise of its rulemaking authority. You have the data system, which is really the engine of a compact. If the commission is the brain of the compact, the data system is the engine of the compact. Not to mix metaphors too much there. But it's a shared database that contains licensure and disciplinary information from each state that is a member. The data system is what allows for the rapid verification of a licensee's credentials in sometimes a matter of minutes for some compacts. You have disciplinary issues. So really one of the challenges associated with interstate licensure is the question of how do we ensure that practitioners with multiple state licenses are being held fully accountable in all states in which they're licensed. This is largely a question of information sharing, and the compact through the data system ensures that interstate practitioners are always in good standing with all of their respective boards at all times. The compact also contains provisions requiring member states to collaborate on investigations of practitioners. So we often hear from licensing boards that tracking down information about adverse actions in other states or investigative information in other states can be very difficult. So the compact facilitates that information sharing. Related to discipline, we also have the FBI fingerprint-based criminal background check requirements. These are a pretty standard feature of licensure compacts and are obviously intended as a safeguard to the public. We recognize that some states may not currently require FBI background checks for all professional licensure. But if we are going to expand interstate practice, we really have to ensure that we are not sacrificing public protection. As I said, this is a standard feature of licensure compacts. If you want to use the compact, you just have to get an FBI background check. That's just the way it works. And then we have some governance questions. So nearly all compacts have associated compact commissions, as mentioned, with authority to issue rules and bylaws, which are binding as law on the member states. The commission is a public, sub-federal, superstate entity that is an instrumentality of the member states, and as I mentioned, is governed by representatives of the member states. So why is healthcare license reciprocity important? Well, we have increasingly a mobile society. Both patients and practitioners, people are moving more often than ever right now. And we have technological advancements in telehealth that have accompanied that. And so compacts, allow for practitioners to be as mobile as they want to be in this, increasingly mobile era, but also to be able to take advantage of telehealth to maintain continuity of care and expand their reach into, underserved areas. You have the deficit and availability of healthcare practitioners. This is something that was, as I mentioned, exacerbated very much by COVID. You saw places that were hotspots would often have shortages of nurses and doctors because of quarantine requirements, social distancing requirements, et cetera. So the compact allows practitioners to be mobile and to move around to address, those areas of need. And then you have practical advancement for current and future generations. So these compacts will stay in effect really for decades and even centuries. And so by acting now, we are not just solving a problem for our generation or the next generation. I mean, we're solving the problem ideally for, even hundreds of years of practitioners. And by doing this now, we're kind of doing the right thing by those that come after us. Increasing public access to healthcare services is a fairly obvious benefit. And supporting spouses of relocating military service members, that's actually a really, really large part of the benefit of compacts is that military families, as we'll get to later in more detail, move on average every 3 years. They're restationed. And that comes with a great deal of licensure challenges. It can be very difficult to have to recertify that frequently. It can be costly. It can require additional college coursework that, again, is very costly. So with these compacts, military spouses are able to avoid being sidelined from their profession. We've even heard from some practitioners that have stopped practicing their professions due to licensure issues. And so with these compacts, we're able to prevent that for military spouses, of which there are, millions in the country. And so here you have a list of some of the major healthcare licensure compacts, really all of the major healthcare licensure compacts. So you have the Nurse Licensure Compact, which is the first and was instituted around the turn of the millennium. And it actually reached 25 states before it kind of stalled, and it had to go back out for amendment. And as I've mentioned, it's very difficult to amend these documents. So it was reformulated and then reenacted as the Enhanced Nurse Licensure Compact, which is now just the Nurse Licensure Compact, and is up to 37 states. The reason why it was 25 to activate the Nurse Licensure Compact was because the first edition had 25 states. And so they thought that it was appropriate to, require that number of states to enact the replacement. But you see a much lower threshold for activation for these other compacts. And that number, whether it's 7 or 10, just reflects what we believe to be political viability. So you have the Emergency Management Services Personnel Compact, which has 22 states, the Medical Licensure Compact, which has 35 jurisdictions, the PT Compact with 33 states in DC, the Psychology Interjurisdictional Compact is up to 25 states in DC. You have the Audiology and Speech Language Pathology Compact, which is new and is actually currently going through its setup of its commission because it reached its threshold this year. The APRN Compact, which is also new and is currently under consideration. And then you have the Occupational Therapy Licensure Compact and the Counseling Compact, both of which are currently going through enactment as well. And also, I wanted to highlight that, as I mentioned, there are some compacts currently under development. So right now, CSG is currently working with professions on compacts for physician associates, dentistry, dental hygiene, massage therapy, K-12 education, social work, and cosmetology and barbering. And the latter 5 of these professions, we are working with under the auspices of a cooperative agreement with the Department of Defense, which again draws attention to how important of an issue military spouse licensure is to the general goals of the Department of Defense, including readiness and such things. So moving on, state participation in licensure compacts has really picked up since the enactment of the new Enhanced Nurse Licensure Compact, and was started in 2016. So since then, we've had 180 separate pieces of legislation. 43 states have enacted at least one of these licensure compacts. 33 states and DC have joined at least 3. And we have 10 states listed here that have joined at least 6 licensure compacts. Your current clubhouse leaders are Georgia with 8, Maryland with 8, and Colorado with 7. And we've also seen in this year some incredible momentum in the state of Ohio, thanks to Representative White and Senator Regner, who have enacted together at least 6 compacts this session, which is incredible. So a little bit about the development process for these interstate compacts. CSG works tirelessly, given how powerful and difficult to amend these documents are. CSG really strives to have a transparent process in developing these compacts. So we convene a very wide range of stakeholders, including legislators, regulators, professionals, industry groups, and, of course, legal experts such as Nahali. We submit public comments on whatever draft is created and then make amendments. And even if the amendments that we make after stakeholder review require another stakeholder review because they're that substantial, we will do that extra stakeholder review. So we want to take as long as it takes to get it right, and to get it right in a transparent manner. Because like I said, these documents are very difficult to revise once enacted, because every state has to enact the same language. So any amendment would have to be enacted by all states. So we just want to get it right the first time. And so our process looks a little bit like this. It's a lot of text, sorry. So we convene an advisory group, which is the first step. And that is the kind of broad project team, so to speak. And that is composed of, like I said, stakeholders, issue experts, members of the profession, state officials, legal experts, and they examine the issues around the profession and current licensure requirements, best practices, and kind of alternatives to the current structure. And they established a set of recommendations that will then be used by the drafting team, which is a smaller group composed of members of the advisory group and legislation and legal experts. And they will craft the actual compact language based on the recommendations of the advisory group. And then we circulate that draft compact to states and stakeholder groups for comment. And that process typically takes a couple of months at least. And we usually have, dozens of interactions with stakeholders and, particular groups. And then the drafting team will reconvene to discuss those stakeholder comments and incorporate them back into the draft. And then that revised draft then goes to the advisory group, which is the broader project team, for final approval. And like I said, sometimes the drafting team will make revisions that end up triggering another stakeholder review. But we have no problem doing that if it's necessary, and we want to keep the process as transparent as possible. And then what we're doing right now is phase 2, which is education and enactment. So we develop a legislative resource kit for state leaders. We develop a website to help folks track compact legislation, and we convene the national briefing, which we call the Legislative Summit for this, to educate key policymakers on the compact, and then provide some further support with identifying state champions for the compact, and providing sometimes informational testimony to legislative committees or to licensure boards that are considering the compact, and then just generally support the profession with reaching the threshold of viability for the compact. So a bit more about governance. So here's the Compact Commission. The Compact Commission forms when the threshold of jurisdictions pass the legislation, which for the Counseling Compact is 10. It is a quasi-governmental entity, so it is neither a state entity nor a federal entity, but it occupies a sort of liminal space in between the two, but it does have the authority by virtue of the compact to issue rules that are binding in states. It's an instrumentality of member states, so it is answerable directly to the member states, and like I said, is composed of member state officials. I already said that. Yeah, like I said, it's suprastate, subfederal in nature. But it is not a private organization, I would emphasize. So a compact commission is composed of voting representatives from each member state. It can form committees. including an executive committee that is responsible for making day-to-day decisions. Commissions are generally granted authority to hire staff, which would then be responsible for implementing the policies and procedures established by the commission. Commissions serve as agencies of the member states and are tasked with acting on their behalf and not on behalf of any particular group or organization. The commission is run by member state officials. It is answerable to member state officials. It is not answerable to any professional association or any association of state regulators or any other outside group. It is controlled by and answerable to member state licensure boards. And so for the final bit of my presentation, I wanted to take a moment to address a couple of common misconceptions that we see fairly frequently about compacts. One of those is that interstate compacts are a takeover of state licensing authority. As I mentioned, compacts are controlled by their member states. Commissions are composed of member state officials. Each state receives one vote. No larger state gets an outsized voice. Every state is equal. And as I mentioned, the commission is a public entity that is an instrumentality of the member states. So if compacts can be viewed as a takeover of licensing authority, it's a state takeover of an issue that is already controlled by states. It's more of a preservation of state sovereignty. Myth number two is that compacts are controlled by an outside organization. This is somewhat related to the first one, but as I've said over and over, the compact is controlled by the commission, which is definitionally not an outside organization, given that it is composed of member state regulators. And the third myth is that commission rules and bylaws will thwart state sovereignty. We vehemently disagree at CSG with this argument because, as we've mentioned, the threat of federal intervention on occupational licensure, due to its anti-competitive nature, is very real, and federal intervention on occupational licensing would thwart state sovereignty much more than states coming together to enact a compact to, in fact, preserve their sovereignty over the issue. We very strongly believe that compacts are a way of protecting state sovereignty rather than weakening it in any way. And so that's all I've got for my little presentation here. At this point, I can take a few questions, and then I will turn it over to Nahali for our deep dive into the compact itself. Feel free to use the chat, or feel free to raise your hand and we'll call on you. I will let the awkward silence linger for just a second. Okay, sounds like there are none. I think we should go ahead and take a 5-minute break though, since Nahali's portion will be probably an hour at least. So if everyone could be back at 9:45, then we'll get started with the deep dive into the compact. Thanks, everyone. All right. Started once more. Does my screen look good to everyone? Cool. Okay, so, turn my camera on here. Nahali Freeland Kalfas, Practitioner specializing in administrative law. For the past 14 years, she's been responsible for prosecutorial hearings, settlements, rulemaking, and legislative matters as general counsel for the North Carolina Board of Examiners for speech language pathologists and audiologists. She received her JD from Duke University School of Law in 1997. Nahali serves as legal counsel to the CSG National Center for Interstate Compacts. She has served as co-counsel for the governing board of the Psychology Interjurisdictional Compact and has also served as one of the principal drafters and counsel for the compact efforts for audiology and speech language pathology, occupational therapy, and most recently for the Counseling Compact. Nahali sits on the board of directors for the National Council of Psychologists and Audiologists and is chair of the Administrative Law Council of the North Carolina Bar Association. She was on the legal team that completed the legal assessment for the Great Lakes Compact Commission and provides compact governance training for the Interstate Commission for Nurse Licensure Compact Administrators. She is one of the nation's preeminent experts on interstate compacts, a fellow Dookie, and a cherished colleague here at NCIC. Nahali, the floor is yours.
Thanks so much, Andrew. Can you hear me okay? Great. So thanks for your attention. I think Andrew gave a really thorough review of compacts and the world of compact law. Just a quick mention that I come to this area having been actually in administrative law for now almost 16 years. And I have really enjoyed working within this not very well known area of law because it's something that both sides of the aisle can agree on. And how rare is that for us? Really what we find is that both Republicans and Democrats alike are interested in narrowly tailored public protection. So the least amount of regulation with the biggest bang for our buck in terms of protecting the public. And this is really what we strive for. And that's why the uniformity that compacts produce is so well received. Obviously, with the pandemic, we have seen a really large uptick in interest in compacts, and that's not surprising. They promulgate the ideas of telehealth, of access to care, of licensure portability for qualified and competent practitioners, and that's an important point. And compacts also do, in fact, retain state sovereignty. And they do this because states come together to collectively govern over the compact. And the only way in which a state is affected in any sort of way that they're not currently is that they can't unilaterally act. They can't unilaterally affect the other member states to the compact. So it has been a very attractive concept, as I said, to both sides of the aisle. It's attractive to us regulators who have been taking some hits lately. We've seen the erosion of judicial deference to the action of board members. And what we really like in the compact world is that we see with an interstate compact a collective cooperation among states that stops calcification that we see sometimes in boards that are too eager to engage in something that may have the appearance of marketplace protectionism. Compacts instead open up the doors for access to care, open up the doors for portability of licensure, and open up the doors to public protection. In fact, because I've been a prosecutor for almost 16 years now, one of the things that I find really, really compelling and important about compacts is that they broaden our prosecutorial net. If your state is a member of a compact, they are able to actually take action on a bad practitioner based on their bad action in another state. All of you who work with boards, or if we have any prosecutors on the lines, but certainly board members, you know the frustration you feel when you can't stop a bad act or a bad practitioner from coming into your state and harming the public based on what they've done in another state. You have to just wait and find them engaging in something that could be harmful. I think this profession especially, we have a critical need for protection of the public. The work that you professionals do is so important, and I mean probably never so important as it is right now in this moment in time. And I know that there has been a real need for additional licensed professional counselors across the country. And I'm certain everyone on this call could give me even more information about that. But obviously, this is something that's time has come. That's why we're seeing so many states join compacts. So thank you for the opportunity to speak to that. Okay, Andrew, you can advance to the next slide. So this is just a little bit of a timeline of what Andrew mentioned about our process. I will note that when you see October 2020, the drafting team reconvening to review stakeholder feedback and make adjustments. I mean, it says 1 month. Let me tell you, I bet we had 5 phone calls lasting multiple hours, of course, all over Zoom because of the pandemic, but amazing work done. The drafting team was one of the most impressive I've ever seen. They really put a lot of thought, genuinely considered every statement made. And this is common practice at Council of State Governments. We think that the only way to really reach consensus and to have good, solid law is to receive that stakeholder feedback and to take it seriously. And that was done in this case. Next slide. Sorry, yeah, thank you. So again, Andrew's already mentioned this to you, but what is the counseling compact? It's a occupational licensure interstate compact. It's no different than your driver's license that gives you the privilege to drive in other states across the country. You don't have to stop in each state and get a new license. But of course, the states that you drive within have the right to take that privilege from you if you do something wrong. So here we have licensed professional counselors with the opportunity to practice in person or via telepractice across state lines, highly needed. Again, they receive a privilege to practice. It's the same thing as a license. It's just a different way to call a license a license. The difference is their privilege to practice in those states is tied directly to their ability to honor and really protect their home state license. We'll get into how someone loses a privilege and how someone loses their home state license a little further in the slides, but this is really how it functions. It increases access, obviously, to care, highly needed, and it increases continuity of care. And I'm not sure I really grasped that until I started working with this group of professionals. And obviously, continuity of care, especially for our military personnel, our vets, very important. Next slide, please. It's very similar in form to all of the existing compacts. We've listed a few of those here. It is the mutual recognition model. What we like about this mutual recognition model, which is how it functions, is that even the Federal Trade Commission came in and said that the mutual recognition model could be a really good model for ameliorating antitrust concerns. You know, what a boon that is to have the Federal Trade Commission actually support a concept as stopping antitrust concerns. And the reason that they came forward with that is because it does require that member states gather together, collaborate, find the least restrictive means possible to allow a competent practitioner the ability to practice in all of the member states. And that's exactly what this compact does. The compact states do have the duty to communicate and exchange information. This is the really important piece of compacts. This is where a compact has teeth, and it has real teeth because if a state does not comply in providing that information, they can be released from the compact. They can lose the right to sit at the table of the compact commission. The reason for that, obviously, is we have a heightened duty to the public because we're allowing these practitioners to move across state lines. With that being the case, we have a heightened requirement to be able to trust one another, to trust the member states. And for that reason, good compact language always includes compliance and enforcement language. And that is the teeth, because what we see with some states with reciprocity, or even with the National Practitioners Data Bank, you don't really have that teeth. Sure, you could risk getting a fine for not reporting to National Practitioners Data Bank, but I'm sure many of you regulators on the line know not everything gets reported. And National Practitioners Data Bank is pricey. No complaining about them, but this is a model that really functions in a much more expedient and protective manner. So states, of course, retain the ability to regulate their practice. What do we mean by that? What we mean is the state still defines its scope of practice, what they will allow that professional to do in their state. Just like the rules of the road when you go into a different state. You know, your state may have speed limits of up to 80, but maybe another state doesn't. So the states get to retain their scope of practice, and the states get to hold a professional who joins the compact liable if they don't know and practice that state's specific scope of practice. This is why we see with most of the compacts, jurisprudence requirements. For someone who wants to have the privilege to practice in your state has to pass a jurisprudence exam. It's not in every state, but in a lot of the states, they want to know that the professionals treating their citizenry understand their law. So you see that retention. That's a bit of the state sovereignty there. The rules of the Counseling Compact are only applicable to states that are member states. Obviously, if you're a member, if you're sitting at the table of the commission, you have to abide by the rules. And this is something that we really try to sort of hammer home. The rules of the compact, they are with regard to governance and administration of the compact. We don't get into substantive rules about scope of practice. That's not what the commission is there for. The commission of the compact is there to administer that compact and to draft rules that help states administer that compact properly in accordance with law. So just like your boards have good governance requirements and are required to only engage in their authorized duties and they're only to work by their authority, a commission works in exactly the same way. If the compact doesn't say that the commission is allowed to promulgate a rule in that area, then it can't. Rules have to be directly authorized by that state law, which is the compact that a member state chooses to enact. If a state has an issue, it can withdraw from the compact. It can do that by repealing the enacting legislation. That I don't even know if that has happened. If it has, I think maybe it's happened one time. It's not common because states find that these work exactly as they're supposed to. Next slide, please. Okay, how can your state join the compact? And this is an important distinction that we'll get into with the sections in a little bit, but there are requirements for the member states and then requirements for the practitioner. So this is the requirement. These are the set of requirements for your state. Your state has to have the following and meet these same requirements for licensure. And you'll note in the first sentence that regardless of the term or the title used for the profession, these are the substantive requirements. The reason for not labeling it is because we do see some differentiation and even balkanization at the different ways that we label the professional in this field. But what we do know and what the stakeholders could agree on is this common set of requirements. And it's laid out pretty well. A nationally recognized licensure exam. We had some states that wanted the exam named, but that's never good practice. Just like in your enabling statutes and for your licensing boards in your states, you don't want to get so specific because you want to be able to pivot, and you have to be able to pivot based on how things may alter or change. So you see that currently states require 60 semester hour or 90 quarter hour master's degree in counseling or equivalent graduate coursework. And you will see some of the areas, and the stakeholder group, the drafting team worked tirelessly to come up with this list. And this is where us attorneys, have to just kind of sit and listen to the professionals, because we know the law, but we don't know your profession the way you do. So we listened to the stakeholders, we listened to the drafting team, and this is what was determined to be the best way to sort of spell out what is required. You'll see that licensees have to complete a supervised postgraduate professional experience. Again, just like with good drafting of law, you want to make sure that you don't get highly specific. You can get more specific in rule, but you can't get specific here because we need to leave it open, and we want to really encourage the highest number of states to participate. And that's really what this group, I think, did well and captured well. Let's not get tied up on names of the professional. Let's not get too tied up in exact, named coursework. Let's make sure that as many states as possible can participate. But let's agree that this is the way that we recognize a competent professional. Also, you have to have an FBI background check. And sometimes we have some kickback or blowback on that, but every single compact requires this. And honestly, the public that we all serve and the public that this compact serves sort of just assumes that the professionals who are treating them, giving them physical treatment, mental treatment, that those professionals have had criminal background checks. Next slide, please. Okay, so the counselor who wants to apply has to be licensed in their home state. And that's their primary state of residence. And that's spelled out with, being able to prove that you spend your time there. They can practice in another remote state through the compact. So the additional requirement here is that they must not have had any encumbrance or restriction against their license to practice in the previous 2 years. That is actually less restrictive than some compacts. Some compacts say that they can't have had any misdemeanor, they can't have had any encumbrance at all. This was seeking to really acknowledge the reality of our time and the reality of legislative trends, which are saying, let's make sure there's a nexus to the practice and whatever mistake a person has made. This does that because we're talking about an encumbrance or a restriction against your license specific to your ability to practice and to provide competent care for your patients. So, so if you've had an encumbrance or restriction, you have to wait out that time to be able to actually come participate. And again, this mirrors almost every compact that you're already used to in your states. You also have to have a valid either social security number or national, I think NPI is an acronym for National Provider Identification or National Practitioner Identification. You have to pay all fees, meet the requirements of the remote state. So you don't get any free pass with what you have to do for the remote state, but you do actually have a reduction in the time that you wait and typically in the fee that you have to pay in order to have that remote state privilege. A privilege to practice, again, can't say this enough. It's the same as a license. It's a privilege to practice in that state, but essentially it operates just like a license. You can bill based on having that privilege. You don't have any less of billing authority. You have the same billing authority. It renews at the same time as your home state license. So instead of, what we found, and I think we have someone speaking later, what we found with our military folks is that some of them were having to maintain these very complex charts to remember when to renew, what their continuing ed cycle was, and these multiple states that they have no choice but to practice in because they have to move so often. And they want to engage in continuity of care with telehealth. So what really makes sense in all of these new occupational licensing compacts is let's tie it to the home state. Keep in mind when you have to renew that home state license, renew that, and then that automatically renews your privileges, okay? It ticks at exactly the same time. And it's satisfied by compliance with your home state continuing ed requirements. Why do we do that? Well, we do that because it would be so cumbersome and just unwieldy to require a licensee to have to do continuing ed in every single state that they want to practice in. So what we're doing, again, we're retaining our state sovereignty, but we're having some trust in our fellow member states and trusting that they have requirements that we can really stand by. Continuing ed is it's kind of a hotbed in terms of legislative trending. What is your evidence basis for having these requirements? So you really have a hard time trying to determine what would be a reason to make someone have to do continuing ed in every single state. We just can't come up with a reason. So the home state continuing ed is what we entrust. Okay, again, active duty service members, we give them a nod about how often they have to transfer. So they can designate one state to serve as their home state for the duration. And the reason we do that is they shouldn't be forced to have to change their primary state, their home state, for purposes of the compact every time they move, which sometimes is as often as every 2 years. So the Department of Defense asked for this, and we complied because this is something we should do for those folks. Next slide. So again, I've talked about the teeth of, of having to comply and upload information to make sure that we're protecting our collective public. So how are adverse actions handled? How do we handle investigations? This is always a hot topic, particularly with EDs of boards and with prosecutors like myself. So basically the best way to understand this is to say that the home state can take adverse action against the license. The remote state takes adverse action against the privilege. Why is that? Because you can only take away what you can give. So only a home state can give a license that entitles you to participate in the compact. And then all of the remote states give a privilege. So exactly what you can give, you have the power to take away. The important thing to understand is that if a home state revokes their primary state of residence practitioner, if they revoke that license, the privilege is lost in every single state. That's exactly how it happens. And the reason why is because it's that home state standing, that home state license that entitles you to, again, be able to drive in all the other states. So if you lose your driver's license in your home state, you don't get to go drive in other states. You have to go get another license there. So if someone loses their home state license, they cannot utilize the compact. However, they could go and get a single state, just in the ordinary way that they do now, a single state license in each state that they want to practice in if they would qualify. But with regard to the privilege, again, we have to trust in a broader way. We have to protect more of the collective public. So this is a way to protect that public. Okay, next slide, please. Okay, how is it administered? Well, once this compact reaches the 10th state, once it gets enacted in the 10th state, then it becomes a real live compact. Because it becomes a real live compact, and we know that it's live, and the reason we do that is we want it to be viable. And if there's only, typically if there are only 3 or 4 states, is that really worth it? Maybe not. So 10 seems to be the magic number for most compacts. So once the 10th state is enacted, then it becomes a real live compact. But have no fear, executive directors, that doesn't mean that just because it was enacted in the 10th state and it's a compact, that doesn't mean that you have to implement it right away. There's always a perfectly adequate period of time between the 10th state enactment and when it's actually implemented, and each state has to start issuing privileges. Plenty of time. I mean, and it varies across the compact world. I mean, just as a benchmark, I think, and Dan, you can put it in the chat if I get it wrong, I think SIPAC had at least about a year before there was implementation. It has even more time based on each state's issue, because some states had a harder time getting the FBI background check. So they got to implement later. Just because we hit the 10th state doesn't mean you're right away issuing privileges. It means that we want to get you started issuing privileges, but you don't have to do it right away. The commission, again, is the governing body. And as Andrew, I thought, very directly said, the commission is absolutely governmental. It is an instrumentality of the states. The commission is not a not-for-profit. The commission is not an association. The commission is a governmental entity that administers this law, this enabling statute for the compact. And because a compact is both a compact and a contract among the member states, it has a pretty heavy duty here. It has to make sure that it's administered properly, exactly in accordance with the authorized provisions of the compact. So how we do that is we have a commissioner, which is a representative from your state, and there's one per state, which is great because some of the compacts have more than one, and it can get pretty daunting. But basically, the state will send a representative who is a member or administrator from your state's licensing board. Now, if you're a state, and there are several, that doesn't have a licensing board, you have some hybrid model where there's an agency that oversees and there might be an advisory group. We have language to cover that. The group that is responsible for licensing of professionals and responsible for regulation of those professionals, that is the person who gets sent as a commissioner, and your state gets to choose that person. They get one vote, and that's important. And if they can't attend, they can appoint a proxy. And because they can appoint a proxy, that proxy has to have voting authority on behalf of the state, because the commission needs to have business done. I mean, the first commission meeting is very important. You establish additional bylaws that aren't actually in the compact law. You establish, you triage and establish the most important rules for like how the database will work, et cetera. Unfortunately, you can't do that in the law because number one, you're not a real compact yet. And number two, you don't know what the member states are going to want. But again, these member states that are sitting at the table, that are first at the table to establish this compact, they can only do what they're authorized to do in the actual compacts. So there's no hiding the ball there. They can only, narrowly look at what they're authorized to do. Okay, we see that we have an executive committee, all compacts do, because Sometimes you need a group of people who can get together quickly. We saw this a lot with the pandemic, where executive committees had to do some emergency rulemaking. But bear in mind, very important that this is really heard. Compact commissions use all the same good governance requirements that you need to use for your board to retain your state actor immunity. So all the same transparency requirements, notice, opportunity to be heard, responsiveness to concerns of the commissioners, all transparent, same transparency requirements. There's, again, no hiding the ball. Next slide, please. Okay, so this is a little bit repetitive. So, and I don't want to take up too much of your time, but we'll go through sort of the key provisions and the things that I think are important. I'll just restate to you, but you obviously in the legislative toolkit, you have the law. And if you don't have access to that, let us know so we can get it to you. But we'll just go through the key provisions. Next slide, please. So we have a definition section. And this particular, so we have the purpose section.
Sorry.
That's okay, no problem. And the purpose sections are largely, except for just nuances with regard to language, the purpose sections of most compacts are exactly the same. We want to facilitate interstate practice. We want to improve access to care. We want to provide public safety and protect the public and make sure that practitioners that are providing that care are competent. Because really, that's the only reason for any of us to exist. Every single state licensing board exists solely to protect the public, not to protect their marketplace share. That could arguably be the work of associations, but no, all the boards that will feed this commission, that will seat this commission, are there solely for public safety. So for that reason, the compact is designed to achieve that, to provide for mutual recognition, to enhance the state's abilities to protect the public, as I told you, casting that broader prosecutorial net, to encourage the cooperation of member states, to regulate practice, to support active duty military, very important, and their spouses, to make their lives better, to enhance the exchange of information. And because I do have involvement with some of the older and larger compacts, like I'm doing governance training for the nurse licensure compact next week. And what I see in these existing compacts is this really happens. There's so much more communication between member states to a compact. And some of the commissioners that I've interviewed in the past have said things like, the act of being in a compact, the act of even considering a compact makes you sit back and look at yourself as a board and make sure that you're not calcified in your thought, because what we don't want to do is exactly what legislators sometimes worry that board members are doing, which is saying, well, I had to do it, so they have to do it too. Let's make sure that the regulation and the requirements we're setting up for these professionals make sense, that they make sense for the narrow purpose of public protection, not for any other purpose. Let's make sure that we're keeping ourselves honest. And that's what this communication does, because you learn the innovations of other states and you see that it can work. So that you enjoy the exchange of all of that. The use of telehealth, I think, post-COVID, or, I hope we could say post-COVID soon, but post-pandemic, the height of the pandemic, we all realize we have to have telehealth. There's no way around it. Support the uniformity of counseling requirements. And obviously, it's very important that we try to strive toward that uniformity. That's why we see all this anti-regulatory movement and action and investigation into that. We need to respond. It's easy to get offended as regulators, and I was initially, when a legislator says, your requirements are too much. And because of course we all know the good work we do to protect the public, and we know that it's important, but we have to show that we can get a consensus together and become more uniform, because it's not true to say, well, my state has the safest practitioners out of every state in the country. We like to say it, it's not true. We just need to come together and make sure that we are vetting these professionals and keeping the public safe in a narrow means. We need to facilitate that practice for folks who meet those uniform requirements. Again, competent practitioners, no less than competent. Okay, next slide, please. Definitions. Please, when you're reading this law, really pay attention to the definitions for two reasons. One reason, it'll help you understand the rest of the compact. The main reason is this drafting team worked so hard on these definitions. I think more so than any other group we've worked with. I think Dan would agree with me. They really worked very diligently. They revised and revised and revised and listened to stakeholder comments. So they spent a lot of time. Next slide, please. Again, we've reviewed this, but state participation in the compact, again, very important. State, this is what the state has to do. The reason that these requirements are important is they necessarily implicate the requirements of the individual, because the only way you get into the compact is by having a home state license. So if a state wants to be a member of the compact, they have to be requiring this of their professionals, of the people to which they would grant a home state license. Next slide, please. So again, here's the privilege to practice requirement, and this is for the individual, but be wary that you read those in tandem, both the state requirement and the individual, the practitioner's requirement, because everything must be met. The criteria must be met in both sections. Again, we had the last bullet point. We place the requirement on the individual to report any adverse action. Okay, so let's say they don't report it, and we've all had this. You know, anyone who's ever done any work for a board knows that that happens. Well, when it's discovered, that's okay. You can take action against that person, and not just the home state. Every party state to the compact can absolutely take advantage of that and say, you know what, you didn't report something you're supposed to. You make us concerned about protection of our citizenry, because you need to be upfront and honest with both your home state and your remote state licensing boards. Next slide, please. Okay, so again, the privilege to practice is valid until the expiration date of the home state license that it tracks. And again, if that home state license is revoked, that's it. That was what punched your ticket as a practitioner to get into the compact. Now, arguably, a person could, do whatever they need to do in terms of disciplinary action and then get another home state license issued. Well, fine. At that point, you can try to apply for the compact again. But again, has to be at least 2 years since completion of any requirements from your previous encumbrance, from your previous adverse action. Next slide, please. And this section, this is kind of new. I think either occupational therapy or licensed professional counselors were the first to do this. And it creates an alternative pathway to licensure for privilege holders. Why? Because we've already vetted them. They've already been vetted. So this sort of continues this quick access to care for our citizens. This provides us, we still have the safety net of knowing any encumbrances they've had and they have to complete all required disciplinary conditions. They have to let 2 years pass. They have to submit themselves to another FBI background check. Why that? We had some stakeholders say, why do they have to submit to another FBI background check? Well, for now, they have to do that because they're getting a new home state license, and we want to protect that home state that is issuing that license, and they need that protection. They have an affirmative duty. So unfortunately, until we flesh out the program that FBI is working on, where we can sort of constantly update and constantly revise someone's background, until that happens, they have to get another FBI criminal background check. Any practitioner can still hold, just like they can now, multiple single state licenses. They can do that. But in terms of their compact privilege practice, they can only have one home state license. And we had some stakeholder feedback on that. Why is that? Because we have to have a means by which to track the practitioner in order to protect the collective public. We can't do that if there are multiple states. We have to have one by which the renewal and the continuing education is tracked. So that's just for clean administration processes. Next slide, please. And here again, we mentioned this previously. This is a nod to our active duty military and spouses. And this is really greatly appreciated. And all of our legislators are very receptive to this. We have been very fortunate at CSG to have Marcus Beauregard, who reports to the Undersecretary of Defense and works with military families to make their lives better. We've been very lucky to have him as a drafting member on this and multiple other compacts. It's good. So we know that we're doing the right thing. In fact, to the degree that the Department of Defense, I believe last year in their National Defense Appropriations Act, dedicated a substantial amount of money to promote the continuance of compacts and to promote new compacts, which was that slide that Andrew showed you about new professions that will come online. Oh, great. Hi, Chris. Got DOD on the line. Glad to see that. So thank you. Thank you for your continued support. And we want to do everything we can do to support our active duty members. And actually, this has the great added benefit of helping everyone, helping all professionals. Okay, next slide, please. Okay, again, telehealth. COVID kind of took my glory away on that one because now you don't even have to justify telehealth. Everyone just understands it. Next slide, please. Adverse actions. Again, I would say most of the questions come up in this area. And because I've had the fortune of actually witnessing how it works in larger compacts, in the 50 state plus territories compacts, in nursing that is moving toward 50 state. This works. There is cooperation between states. The Nurse Licensure Compact Commission even has an annual conference where they talk about joint investigations. How do we work together? How do we, find some economies of scale here, help each other? And a lot of investigators or EDs have concerns about that. And that just doesn't play out with compacts because there is this heightened cooperation. And in terms of expenses, have yet to hear any state complain about expenses because often they're shared. That gets fleshed out by rule once the commission gets seated and comes to the table. That is a detail that the member states to this compact necessarily must create. They must create their own way to govern that and to administer that. And so we wait until we see who's going to come to the table. And that's one of the benefits of being one of the first states at the table, because you have a good hand in drafting those rules that must be approved by the full commission. Next slide, please. And you see a little bit more about joint investigations. Again, casting a broader prosecutorial net. That's kind of my dream as a prosecutor, to be able to reach this bad action in another state before it affects my citizens. It's a great way to really take away the practitioner who would do harm to the public. If a licensee, this is the third bullet point that I'm speaking to, if a licensee changes their home state during an active investigation, form shopping, that former home state completes the investigation. They do that because they have the information. They're in possession of the information. So that just sort of follows logically. They take appropriate action with its laws, and then they upload that information to the data system, and then the other states get to make their decision based on that. Member states retain the right to require a licensee to participate in alternative programs. Okay, this is just good policy. Excuse me. We see this across the states and across the professions, that alternative programs for mental health and addiction, and I guess that is mental health and addiction issues. This is important. We need to allow this. We're never going to take that state sovereignty away where they can decide how a person is going to be treated. And we want to give the practitioner who needs the help, we want to give them the motivation to actually do it. So the compact allows for that. Next slide, please. Okay, establishment of the commission. We discussed this. One commissioner from each state, from the agency or the board or the agency that's in charge of licensing and regulation, one vote each. The commission is directed to establish a term for commissioners. Again, we want the party member states to determine how they're going to govern themselves. And this is a little hard, particularly for us lawyers, because we like to know things ahead of time. But the reason we leave this to the commission is, us drafters, we're just sitting here. We're not actually taking place in the administration of this compact. And, we haven't been the legislator or the licensing board that decided to join. So it's important that we wait until those folks are at the table. But by and large, and I think Dan would agree with me on this, most of the compacts operate in very much the similar manner, because we've all kind of tried to say, let's not try to reinvent the wheel where something's working with another compact, with nursing or with SIPAC or with PT. So often we look at, as benchmarks, we look at their rules and their bylaws, and we kind of use those as a template to consider. So we don't, nothing too crazy happens. All of the compacts operate pretty much the same. And you see, again, the executive committee, all commission meetings open to the public. Council, whoever gets appointed as general counsel for the compact, has to affirm that it's appropriate for any commission committee or for the full commission or again, the executive committee to go into closed session, just like with your boards. Works exactly the same way, same concepts of transparency and good governance. Again, the great thing about being the designated representative from your state regulatory board, agency, whatever it's termed in your state, is that your state actor immunity follows you to this commission. Not only does it follow you to the commission because you are representing your state in that compact commission, not only does it follow you, but the compact, which has been enacted as law, clearly states that your immunity is provided for you there. So your immunity travels with you. Next slide, please. The data system. Again, member states submit uniform data sets to the data system. We have some concerns about the FBI background check. The only reason that is required and the only way in which it's utilized is to give a check mark. Yes, this person can participate, or no, this person can't. Information contained therein is never reported to the data bank. Only yes, they can participate, or no, they can't. So I know a lot of state AGs have concerns over that, and that's precisely why none of that substantive information is fed up, just whether or not they can participate. Again, adverse action. This is very important. We have to know what disciplinary actions have occurred. So that gets put into the data system. When all conditions are met and it's over, then it gets purged. Member states can designate the information that may not be given to the public. The member state retains their sovereignty with regard to how that information is used. The main thing is that they have to share disciplinary information with the other member states. We can't unilaterally hide the ball. We have to share with those that we are trusting, and they have to be able to trust us. Next slide, please. Rulemaking. The rules of the commission carry the force of law in all member states. Why? They have to. We have to be able to administer and govern this compact. And when a member state chooses to enact the compact, when they make that choice, they are consenting to that. So, for instance, for me in North Carolina, we have a very complex rulemaking situation. We have a rules review commission that first vets the rules, determines whether or not it can go up, and then it can also be reviewed by Administrative Procedures Oversight Committee in the legislature. So the thing about this commission is those rules don't go through that state process. And the reason they don't is because these rules are solely to governance and administration of the compact. They're not as to substantive scope of practice issues. So these rules merely do what the commission is clearly authorized to do by virtue of the compact. This is an important point, this bullet point. However, a simple majority of the member state legislatures, if they find some rule incredibly egregious, then they can veto a rule. And the procedure for vetoing that rule is actually in the section on rulemaking, and I believe it states that if a majority of the legislatures of the member states reject a rule by enactment of a statute or a resolution in the same manner used to adopt the compact within 4 years of the date of the adoption of the rule, that rule can have no further force and effect. So if something, incidentally, this has never happened, never in any compact. So, and the reason it hasn't is because the commissioners who are representatives of the state who come to the table, they're already keeping an eye out. They're vetting these rules. They're not, rules only get promulgated in the same way that boards promulgate rules, exactly the same governance. So, notice, opportunity to be heard, vote by the full commission. So for this to be implicated, something has gone really awry, but it's basically provides a little a little breathing room for our legislatures, lets them know, okay, yes, you have to not act unilaterally, but see, you do have your sovereignty. Again, this is never, no commission has ever had to resort to the second bullet point, but it's there. It's there to provide some ease and comfort to the legislative bodies. Changes to the rules, to just regular rules, require a 30-day notice of proposed rulemaking, opportunity to be heard. Okay, same, very similar to most of your state boards. And here again, if the commission issues a rule that doesn't have a direct tie, isn't directly authorized by the compact, again, your state law, because a member state enacts the compact, if they do something that was not authorized, it's void, because we work by the same principles your boards work by, same sort of governance. Next slide, please. Okay, every single compact has a means by which dispute resolution can be worked through. And this is the teeth. Again, this is the teeth. States have to comply. If you join the compact, we're all counting on each other. So you have to comply. How do we do this? Well, we say, most compacts have a compliance committee. And the good thing is, even with the really large compacts, what you see is one state picks up the phone and calls another and says, hey, weren't you supposed to get me this information? Wasn't this supposed to be uploaded? You work together. But if that doesn't work, then there's a period of technical assistance by the commission. Say, okay, why aren't you fixing this? Try to help them. And then if that still doesn't work, then there are always dispute resolution processes. Being terminated from the compact, that's the last resort. And I think maybe the only instances that I recall with other compacts and not even health related fields is for non-payment of fees due to the commission. If there's something due to the commission, maybe that would lead to terminating a compact member state. But this is just not something that happens. There's a lot of cooperation. The member states work together. The commission makes sure that folks have ample opportunity to correct any sort of misunderstanding. Next slide, please. Okay, this is what I said earlier, and this is to sort of make everyone feel better and not be panicked and not feel like you're going to be scrambling to enact the compact, because a lot of states have these concerns. The executive directors who have to do the work of your licensing boards have these concerns. I'm already so busy, and oh my gosh, if we have all these privilege holders, then I'm going to have my ordinary license applications and have to do this other work. How are we going to do that? You have time. There's plenty of time between enactment and implementation. I mean, for one thing, we have to come together as member states and figure out a time we can meet. We're still waiting to do that for speech and language pathology and audiology. So we have to come together. Then we decide, okay, where do we all stand? Who's ready to enact, who isn't? Let's give everyone some time. So there's plenty of time for this. And nursing is doing some research. The Nurse Licensure Compact is doing some research and trying to gather some data, which I'm really looking forward to. But by and large, when we have speakers from the Nurse Licensure Compact Commission, they always tell fellow executive directors, I thought it was going to be this much work, this much more work, and it really wasn't. And that's because the database does a lot of the heavy lifting for you. Do you have to feed information up? Yes, you do. And if your home state licensee wants to participate in the compact, do you go by a similar process that you do now? Yes. But with the privilege, do you have to do the same amount of work? No. So what we find is that the concerns of executive directors are largely cured within a year or so of getting into the compact, and you have the time that you need. If your state wants to get out, it can. And again, member states can decide together to amend the compact, but you really don't want to do that. That's why CSG works so diligently to make sure that what we have is good, solid law. The Nurse Licensure Compact, the first one that came into existence, just didn't have rulemaking provisions, and you got no teeth without rules. You can't enforce compliance. You can't govern the way you need to govern. So they had to amend to get those rules in and to get a set of uniform criteria. They call them the ULRs, Universal Licensure Requirements. And they didn't have that in the first one. So that's why they amended. But, obviously want to make it as broad as we can so that you don't have to amend, because we all know how difficult it is to get law enacted in our states. Next slide, please. Okay, very common. This is boilerplate construction severability. Okay. This is really what AGs always ask us. So the compact, because it is a contract and law in your state, supersedes any conflicting state law. Why does it supersede? Well, the same reason, if I think maybe a way to look at it, number one, there's ample US Constitution rights for that, and there's ample case law from the Supreme Court explaining that. But kind of another way to look at it is it's newer law. It's superseding conflicting state law. And remember, a compact is your state law. So it supersedes conflicting state law. Does it supersede all law? No, just that which conflicts. And this is very important. If there's something in your state constitution that the compact conflicts with, you keep that. It's only law, not state constitutions that the compact will supersede. A compact law will not supersede a state constitutional provision. Next slide, please. Pardon me. So the binding effect, I think we've discussed this plenty. It just reiterates that the rules and bylaws, they're law, okay? Your laws would authorize you to create those rules and bylaws, but they are all tied together, just like for your boards, works just in exactly the same manner. The rules and bylaws have to be authorized by that law. If they are, you have to follow those. Those are the rules of the road, literally. And without that teeth, we couldn't have compliance and we wouldn't be doing our job of protecting the public. And that's really what this compact exists for. And again, it enforces that any practitioner seeking to use the benefit of this compact privilege better know each member state's scope, or excuse me, each member state they wish to practice in must know that member state in which they seek to practice. They have to know their jurisprudence of that state. They have to abide, just like you have to abide by the speed limits in the state next door to your state. You have to abide by those rules. You have to know them, and you can't use your ignorance of them as a defense. You can't. You have to know them. And of course, legal precedent. And there's a whole horn book on this area of law and compact law. And several of our colleagues in the legal field with NCIC, the Council of State Governments, actually drafted that compact treaties, that horn book, and you can get it. And it lays out all of the very long legal precedent with regard to the fact that compact law can supersede state law, not state constitutional provision, but can supersede your state law, so you don't have to worry about that. Now, questions still come up, and commissions often have conversations with AGs to sort of work through that, and that's okay. That's a necessary part of working together. So this was very long. I'm really appreciative of your attention. I think I'll go down and look in the chat. I'm hoping that my colleagues have been able to monitor the chat, but Andrew, if there are any remaining questions from chat, feel free to toss them to me and I'll respond to them accordingly.
Well, first of all, if anyone else has any new questions, feel free to use the chat or raise your hand. Dania asks, what is a horn book?
Hey, thank you, Dania. Here, I think I'm still in law school. That's what us older lawyers call a law book, but basically it's just a book that explains the law. That's it. It's just like, you in your profession, you would have books that explain the different areas of practice. It explains compact law, and my colleagues at CSG can give you that information. Actually, I think I have the book right here. I'll show it to you, but there it is. And, so we like our colleagues, Rick and Mike McCabe, like to joke that it's the bestseller in the American Bar Association's administrative section. And they don't want to ask what that means. That could mean that there are 5 that have been sold, but it will give you a very comprehensive look at the law behind this.
Thank you. And then there were a couple of questions in the chat that I wanted to highlight for us. Bill Green had asked a question that relates to concerns about additional administrative costs for boards. I know that I answered that we generally take the position that the license privilege fee that states can assess generally offsets any additional costs. I wanted to see, Nahali, if you had anything more to add to that.
Yeah, I think that's a fair statement. I mean, you see with most of the newer compacts, many of them don't even carry fiscal notes because it's sort of a break even proposition. Again, economies of scale because you're using a database. Is there language in that compact to allow for an assessment? Absolutely has to be. You have to in any organization. So certainly in a governmental organization that is charged with administering a law. However, in practice, particularly like in some of the longer existing compacts, you don't see huge assessments to each state. SIPAC, for instance, has a sliding scale. They charge member states based on the number of people who actually join the compact. That's one example. I kind of like that. It's pretty creative. So that you're just paying for what you're using in terms of people who are participating. I think in PT, and Dan, correct me if I'm wrong, or Andrew, correct me if I'm wrong. I think in PT, it averages about $45 for the individual. And I can't remember what the average state assessment is.
Well, that's what they encourage states to do, but states can, I think Maryland charges like $125.
Right. And if your state needs to, then you can. You have leeway to offset any participation costs that will be charged to your state. You can offset that with the fee to the individuals. Obviously, you want to encourage participation, so you want to keep that number as tight as you can. I'm trying to think of any examples of member fees. Most of the professions have the good benefit of having some help from associations. And I'm not making any promises about that, but almost every compact gets grant and association help.
Yeah. I think nursing charges $6,000 a year to all their states. And SIPAC has that sliding scale based on the number of privileges issued.
Which is far less than 6,000.
Oh, yeah.
And also bear in mind, nursing is, I think it's still the largest profession.
Yeah.
Second only, the nearest one is probably teaching, and that's still like 1 million less practitioners. So nursing is if you want to look at the work done by a nursing board versus the work done by virtually every other health field, big differences. So yeah, there's that fee, but and again, even the medical licensure compact, they receive large grant monies to subsidize what states would have to be paying. And they have money, but they still get grants awarded. So you see a lot of grant help. You see some association help with some professions. So I wish we had hard numbers to tell you, but we don't have a real live commission. So we don't have a way to tell you, in terms of being intellectually honest, I can't crystal ball it for you, but we see many states not even filing a fiscal note because it has so often been just a net proposition.
Great answer. Thank you. We also had a question from Shannon about, and this is a question we get fairly, I guess, what other not strictly labeled counseling professions that may end up being eligible for the compact? I think that's something that would probably be, spelled out by the commission. To those requirements that we've listed out. But yeah, which one are you?
Well, I'm just not sure that's a real issue. I think the compact is specific to the counseling profession. It's, we defined a licensed professional counselor, somebody who could independently assess, diagnose, and treat. We picked the LPC label because we had to pick something. I know a number of states call those things different things. So your state may call it a licensed mental health counselor. But again, if you as a professional have a license from the state counseling board that allows you to independently assess, diagnose, and treat, then you're likely eligible for the counseling compact. So, we, again, just for sanity's sake, we had to pick a way to identify that, and we didn't want to list out what 100 or what 50 states might call that independent practitioner. And also that may change. So the most prudent thing to do was, here's who it's for. And for terms of sanity and for the compact, we're going to call it a licensed professional counselor. Your state may call it something different, but what it boils down to is you have to have a license from the state counseling board, and it has to allow you to independently assess, diagnose, and treat. And if it does, then you're likely eligible. But again, we'll have to see how that rolls out. But that's essentially who the compact is for.
And not to pile on, but because I think Dan's answer really hits it, section 3 and 4, I believe. You look to those. Can you meet that criteria? Then yeah, you get to utilize the compact. But even I think 3 years ago, I was speaking to marriage and family therapists, and at that time they were thinking about name changes and title changes. And so because those things do change over time, we just don't have the luxury of, unfortunately, of naming them all, because that may change. So best way to do it is through requirements.
I mean, yeah. Well, I mean, we're running into this with the physician's assistants compact. They've now decided as a group they want to be called physician's associates. And we're almost finished, and so we're trying to figure out how are we going to. And no states have taken action to do that yet. Some will, some won't. So the best thing we can do is define who's it for. We might stick with physician assistant and give the commission the ability to tweak the name if it needs to, if you have a critical mass of states that change it. But again, the important thing is your license issued by a state counseling board, and does it allow you to independently assess, diagnose, and treat? If it does, then you're likely eligible for the compact.
Got it. And this question, the last, but we also had a question about the exam. Obviously, the compact does not specify a particular licensure exam because exams can change. But professional identity is obviously very important in the counseling profession. So Holly, what would you think about, I guess, the likelihood that the exam designated will be the recognized counseling exam? I mean, it's essentially certain that the commission will.
Well, can I take that?
Yeah, go ahead.
I like to. I mean, the PT compact does not identify an exam. The nursing compact does, and if you talk to the nursing compact, they tell you they wish they hadn't have done that. This is just the best practice that we use over the years. You let the commission identify the exam. You want to leave these documents broad enough that the commission has room to maneuver, and it's evergreen. The more specificity you have, the less ability the commission has to stay evergreen. And the likelihood is then you'll have to go pass and enact another compact. So you want to be as broad as possible without it being absurd. And I think that we've done that with all the compacts that we've worked on. This is easy. These compacts are a reflection of current state practice. So, the exam that the states use is what the commission will identify. I don't see this as an issue or a problem. Again, the other, speech compact, we didn't specify a profession. PT doesn't. Again, nursing does, but if you talk to them, they'll tell you they wish they had. So, this is easy. The commission will do that, and we'll roll right along, because the compact and the commission actions will reflect what's currently happening in the states. They're not there to set up an entirely new regime.
Thanks, Dan. Well, if there are questions, we can move on to our next panelist. We were going to take a break here, but I think we'll do it after our next panelist to keep us a little bit more on schedule. She has a bit of a tight schedule. So without further ado, we're going to hear from Dr. Aisha Dickerson, who is the chair of the American Counseling Association of Georgia. She is a national certified counselor, approved clinical supervisor, and a licensed professional counselor in Georgia and Alabama. She's the owner and operator of AD Advantage Counseling and Education, and associate professor at Adler Graduate School. Although she's made her home in Georgia, Dr. Dickerson provides other services throughout the U.S. and other countries. She is very national organizations. She is the chair of the American Counseling Association of Georgia and serves on a national board for Certified Counselors Minority Fellowship Program Advisory Council. Dr. Dickerson has served as a speaker for multiple national media outlets and large corporations, including social and cultural diversity, addictions, and blended family issues. Her goal is to educate, encourage, and enrich the lives of her clients, students, and the community through her commitment to advocacy, mental health, family wellness, and leadership. Dr. Dickerson, thank you for joining us.
Thank you all for having me. I'm excited that so many people are still involved with getting this counseling compact passed in other states. I know in my state it's very important, not just because you have people like me who are licensed in multiple states for various reasons, but we do have a few military bases here. And in the county where I live, Gwinnett County, which is considered one of the most diverse counties in the nation, we have a hard time finding sometimes people to translate what our clients are trying to say to us, but we thought that the counseling compact would be very beneficial to us because we like our clients to be able to connect with counselors who speak their native languages. So that's one of the reasons that I was so excited about getting this started. Now, I just have a few bullet points here, and I'll say that the biggest part in getting this started was us connecting with what's called the Licensed Professional Counselor Association of Georgia. In the beginning, we were trying to get in contact with senators and representatives who would be willing to sponsor the bill. And then getting in contact with my own representative, I found out that there already was a sponsor, that the American Counseling Association was just not made aware that our other state organization, LPCA of GA, had already gotten the process started. Now, ACA of Georgia is a division of the American Counseling Association, and LPCA of Georgia is a division of the American Mental Health Counselors Association, AMCA. I'm just going to call it AMCA. So although I, as ACA of Georgia chair, have had a lot of conversations with the national AMCA, we just did not have communication at that time with LPCA of GA. Now, once we were able to get in contact with them, which was not the easiest task, we tried our best to work with them. And then the end, I mean, the compact got passed, but the first thing I want to mention for any of you who are interested who are interested in getting involved with doing this compact is to connect with other organizations who would also benefit from having this compact passed. LPCA of GA is only for LPCs in Georgia. The ACA of Georgia is for all counselors in Georgia. So the LPCs, the school counselors, the addictions counselors, as long as they have master's degree students, counselor educators, LPCAGA is a lot more specialized, but still we have a lot of the same goals. So once we were able to connect and have a few meetings, then, you know, it was just a part of it was just supporting each other and keeping each other abreast of what was happening on both ends. So the sponsor that was identified was Dave Belton. He is the representative of the Buckhead area. You might not know a lot about Gwinnett County when I say Gwinnett, but a lot of people who've been to Atlanta know all about the Buckhead area. So Dave Belton is the representative there, and it was House Bill 395. So I'm sure I haven't been here in this morning, but I'm sure you all have at the least heard about Dominique Marcelette. She was my contact person at the American Counseling Association who knew people who I couldn't get in contact with, and I knew some people that she didn't know. And again, it's all about working together and networking. And once we got together, it was set up for us to testify with the Senate. So the House Bill 395 passed in the House. Next in Georgia, it has to pass in the Senate. So we were prepared to speak there and also sent any letters that need to be sent, but the testimony was delayed because of questions about requirements for internship. And so another important thing, so number one is networking. Number two is being available to answer any of the questions that your political representatives may have, because they don't know anything about counseling. And they thought that our counseling compact didn't say that students had to have internships. And, you know, like one random person was like, I know a counselor and they have to have internships, and this doesn't say anything about internships. Well, what the Counseling Compact does say is that the counselor has to have graduated from a master's program that, you know, meets certain requirements. And any of us who are counselors, and myself as a counselor educator, know that that requirement is an internship. It's just a part of it. So to us, that seems simple, right? Like, well, if you graduate, of course you've done an internship. To them, it didn't seem as simple. So it was up to us to kind of explain that to them. And once it was explained, they delayed everything, but once they got the explanation they needed, then we were able to be present and testify in the Georgia Senate hearing on March 10th. It was a really short process, but we were there to answer any questions. They didn't have any other questions. And eventually it was voted on favorably by the Georgia Occupational Regulatory Review Council, which for short we call GORC. They are the people in Georgia who, and let me say, in Georgia, we comb through documents repeatedly. And so if something passes in Georgia, which we're always on the national news about what's passing in Georgia, understand that it was read by a ton of people. So GORC read over it. They voted favorably for this House Bill 395, and then eventually it passed through the Senate. The next step was for it to be reviewed by the governor's office, not necessarily the governor himself, because there are a whole lot of other people who get paid to review documents for him, basically his own personal lawyers that he hires for the state to go through and make sure that there's nothing in the wording that would make him look bad or will be illegal for him. That took like another few weeks, and then next was the bill signing. So one special thing about Georgia is that in order for a bill to be turned into a law, it does not necessarily have to be signed by the governor of Georgia. He has to actively veto a bill in order for it not to turn into a law. So if he misses the deadline, it's okay. Whatever is there that's been signed by the House and by the Senate is automatically turned into a law. Now he signed this one. That wasn't an issue. But another thing is, you know, we put a lot of work into this. So we wanted to be present for the signing of the bill, you know, take a nice picture and, you know, here's ACF Georgia and LPCA. And we did a lot of back and forth emails trying to make that happen. But in the end, our governor had decided that there weren't going to be any more public bill signings because of a few weeks before he signed what was on the national news as the voter suppression law that put a lot of other things in place for our people who vote in Georgia. I won't go into detail about that. The actual law is online if anybody wants to read all 100 some odd pages of that. But because that door was closed when he signed that, and there was a political official who was arrested, and we were on the national news and Biden was talking about it, our wonderful House Bill 395 kind of fell by the wayside and was deemed not as important. And therefore they determined that they didn't need us there to sign it, but he was going to sign it, and it was done. So although he didn't have to sign it, it is signed. There is no wonderful picture, even though, you know, I had a whole outfit ready. That's okay. We've got it signed and we're ready to move on to helping any other states who want to get it in place.
Peterson, for that excellent summary of the process to get the bill across the finish line in Georgia. What questions do we have? Feel free to use the chat or just start talking.
I like to think I did a great job explaining when there are no questions.
Yeah, just trying to exercise good facilitation habits here, letting the the pause marinate for a little bit.
Thank you. And hi, Dr. Ford. I see you as well. Thanks.
Cool. Well, it doesn't look like we have any questions for Dr. Dickerson. I know you're on a tight schedule, so I really appreciate you joining us, and enjoy the rest of your day. And I think at this point, we'll hear from our next presenter after another short break. Let's reconvene at 11:05. Is that good with everybody? All right, see everyone in 5 minutes. Okay, I think we're ready to get started once more. If John is with us, go ahead and turn your camera on. So I'm thrilled to introduce Dr. John P. Dugan, who will provide a perspective on really what it's like to be a counselor who has licenses in multiple states, what that means, and what sorts of burdensome licensure requirements that one has to deal with to maintain licenses in multiple states. Dr. Dugan earned a Doctor of Education in Counselor Education and Supervision at Argosy University in Northern Virginia. John's also a graduate of Marymount University in Arlington, Virginia, with an MA in Counseling Psychology, and the Washington Theological Union in Washington, D.C., with an MA in Theology. In addition, John's postgraduate training includes an Advanced Telehealth Coordinator Certificate at the University of Delaware and the Law and Leadership in Healthcare Administration Certificate at the Mitchell Hamline School of Law. John is a licensed professional counselor and a board-approved supervisor in the state of Maryland. He is also a licensed professional counselor and licensed substance abuse treatment practitioner in the Commonwealth of Virginia and an LPC in the District of Columbia. Dr. Dugan is a senior manager of continuing and professional education for the American Counseling Association. He brings unique perspectives practicing as a professional counselor in multiple jurisdictions and can speak uniquely to the value of the Counseling Compact. John, it's great to have you here. Feel free to take it away.
Hey, Andrew, thank you so much. I have my camera up to preserve bandwidth because I'm mobile right now. Are you able to hear me okay?
Yeah, sounds great.
Perfect, thank you. Well, good day, everyone. And I see so many familiar names and faces of many colleagues from different backgrounds and work settings. So I'm delighted to see all of you here today. And it's a pleasure to speak to y'all on this particular issue. My lens today, even though I have many different hats that I wear as maybe an adjunct assistant professor, educator, supervisor, and so on, but this is really to share some practical or pragmatic relevance of the Counseling Compact to the daily life of a practitioner and to our clients. So as Andrew had mentioned, I am licensed in the state of Maryland. That's my initial license here, jurisdiction. I then later became an LPC in the District of Columbia and later the Commonwealth of Virginia. What I would say is that because I lived in a kind of a tri-district area with a lot of mobility, meaning that a person typically can live in one state and work or travel across jurisdictions multiple times a day or a week. I'm looking at this through the lens of client welfare as well as practitioner ability to engage in our professional practice. So from a client welfare and dignity perspective, which is how the ACA Code of Ethics really, the lens through which we view our scope of practice, if you will, it's making it accessible. And it's really a public interest issue from my lens. Speaking as a practitioner, I'm not a lawyer or a regulator. But I also think that there's an issue related to access to care, which is that one of convenience, and also, as I had mentioned, paying attention to mobility, whether it is one's job, family members, Now we have the virtual presence for telehealth, and then there's the physical presence of actually moving around the jurisdictions quite frequently, and that's one of practicality or necessity. Some of the practical issues that I would raise to you is looking at how it is that a practitioner can best serve those clients that will come to see us. For example, I frequently in my private practice would have clients from Northern Virginia, the District of Columbia, as well as suburban Maryland, and actually some that would come from Central Maryland to my practice, which was in Silver Spring, Maryland. So there was a lot of mobility, and there was a need for me to ethically respond to needs of clients, sometimes kind of quote unquote, if you will, after hours, or to be attentive to their care at times when circumstances might not allow them to be present. And I needed to have some form of practice privilege in one of these jurisdictions. For example, if something happened, there was an urgency or an emergency, I needed to be able to practice sometimes in a jurisdiction so that I could be of best service to the client. I raise that as an issue because there are times when I would have more clients on my caseload in my practice who lived in Northern Virginia and DC than I may have in Maryland. And another example would be, I had a lot of students, let's, as an example, say they're coming from the University of Maryland, which is very close to where my practice was located. If a student was transferring to the Eastern Shore, I don't know the resources. I don't know the community resources, the practitioners for interdisciplinary care, the physicians, and so on, that may be required for offering a client the best practices. So even though I'm licensed throughout the entire state of Maryland, which is the first jurisdiction where I gained the privilege to work as a licensed clinical professional counselor in Maryland, it did not make sense for me to actually follow a client who was going to be permanently relocating to Eastern Shore, whereas the bulk of my practice, the people with whom I worked, were actually located in jurisdictions other than my primary one. So what that meant was I had to go out and become licensed in these other areas, these other jurisdictions. Excuse me. I would say that one of the questions that comes up, or a few of them, are the ability to provide ethical care in situations such as after hours or during times of a critical incident. And like clearly we're experienced with the struggles of a pandemic, a global pandemic, but there have also been incidents in the mid-Atlantic region, such as inclement weather. Those of you that may have remembered Snowmageddon, as we called it, or there was the derecho. Those were incidents that really closed down the region for sometimes a week and a half. Imagine having your practice without not having access to a physical office, and yet having clients dispersed in multiple other jurisdictions. We've had protests, some riots, road closures and such, where it is impossible for somebody who may be looking for continuous care to be able to come in and make that appointment. And so trying to ethically and responsibly follow up with people from diverse locations. I will add that over the years, I have had, even though I'm licensed in 3 jurisdictions, I've had people seeking my professional services as a counselor who reside in West Virginia, in Pennsylvania, and Delaware. So even though I have 3 licenses currently, there was the possibility of actually having folks from further afield, if you will, to seek seek that support. And I think that having the ability to access care, and also for the practitioner to be able to seek employment in different areas, where it's not uncommon for somebody to be a resident of one area and actually drive 15 minutes and to be having a full-time job in another region. Some of the logistics of an application by way of reciprocity are really complex, and to summarize it, I'd say they become expensive, highly duplicative, constantly turning in the same transcripts, getting perhaps an identify fingerprinting and things like that. And after a bit of time, you're maintaining all these different licenses and different continuing education credits and being aware of jurisprudence issues. It really does become at times cost prohibitive to be able to engage in professional practice and honor the best services that one could offer to their clients. What I would say is that as I'm traveling, I am currently back in my home state where I grew up, and up in New England. And what I would say is that, if I were to seek licensure up here in New England, in one of the New England states, the last time I reviewed the requirements, I would have to actually go back and take a couple of more graduate classes, which I'm already teaching. I'm already qualified, and I'm actually teaching at the graduate level. And I would have to go back and get further supervision, even though I've been a practitioner in some way, shape, or form for more than 20 years. And as a licensee for close to 20 years, I would need to go back and get post-doctorate or post-master's supervision to become licensed in another jurisdiction. So if you can see some of the challenges of, actually having the experience and being attentive to the client needs and welfare, sometimes it is making it more difficult in an era when we're seeing a highly mobile society. We're facing multiple behavioral health needs, whether it's through the pandemic, the opioid crisis, and other issues that are on the forefront, and really addressing the need of a lack of practitioners and the ability for one to be able to engage in professional practice, and in some areas to provide supervision to new professionals who are seeking, the initial, in some areas is a couple of tiers, but the initial licenses so that they can have the ability to be qualified for licensure in an initial jurisdiction. So kind of offering a wide perspective, but Andrew, I'll toss it back to you and see if there are some questions that some may have, but just trying to offer a thumbnail sketch of what is it like to be in private practice, specifically in a dense metropolitan area where ultimately one really needs to engage in 3 different licenses or more in order to comply with regulatory issues as well as ethical practices.
Great. Thank you so much, John, for that excellent explanation of the challenges, the unique challenges facing a multi-state practitioner. Do we have any questions for Dr. Dugan in the chat, or if anybody wants to chime in here, feel free. Okay, that's a pretty convincing silence. So we can move on to our next panelist. Thanks so much, John, for joining us. So now we get to hear from someone who has perhaps an even more unique perspective and a very relevant one. Someone who knows what it's like to deal with the challenges of licensure as a military spouse, and who can also speak to the unique need for mental health services within the military as well. Dr. Elizabeth Bergen, PhD, NCC, LPC, RPT, is an assistant professor at the College of William and Mary and serves as the program coordinator for the Military and Veterans Counseling Program. Elizabeth is a military spouse and licensed professional counselor. She earned her Doctor of Philosophy and Counseling from the University of North Texas and is a Pat Tillman Scholar. Her research areas of interest include military populations, play therapy, and adverse childhood experiences. Dr. Bergen is an author on the exemplary practices for military populations endorsed by the American Counseling Association. Her experiences providing clinical services have been in university counseling, home-based and community agency, outpatient, and public school settings. She has counseled individuals with addictions, serious and persistent mental health concerns, adults and children within the military community, and in foster and adoption systems of care. Dr. Bergen, thanks so much for joining us, and I will turn it over to you. When you want to advance to the next slide, just tell me.
Thank you, I appreciate it. Good morning, everyone, and thank you for making time to be here. And thanks to Brian Banks and Andrew Bates for including me in today's discussions. I'm a military spouse of 10 years to an active duty soldier, and I'm a licensed professional counselor. I earned my master's degree in counseling and human services from a 60-credit KCREP accredited program. And since that time, my military family has lived in 5 different states. In each state, I pursued opportunities for clinical practice and have experienced different barriers to licensure and employment, 2 issues that I think are highly related for military spouses. I'm also speaking to you all today from my identity as an assistant professor of counselor education and program coordinator of the Military and Veterans Counseling Program at William and Mary, where my job is to train counselors in best practices for counseling military populations and to conduct research to address critical mental health needs in the military community. So today I'm hoping to share with you some of my professional experiences and perspectives that make the Counseling Compact important to me and my military spouse colleagues, but as well as to military connected persons who may be seeking mental health care. So the most central issue for military spouses pursuing licensure portability may be that states have differing requirements for graduate education, supervised clinical experience, and post-licensure years of experience to seek license reciprocity. So these interstate differences can create disproportionate barriers to license portability and employment among military spouses. Particularly, that means that while an individual may exceed minimum requirements for licensure in one state, they may be required to take additional graduate courses or to accrue additional supervised clinical hours upon moving to a new state. So meeting new state requirements can contribute to financial hardship due to the direct costs of meeting those requirements. And it can also delay the transfer of a license. And both of those things can result in lengthy gaps in employment and then lost wages due to underemployment. The most difficult career transitions have occurred for me in the process of applying for licensure and counseling jobs in new states. So many states require the site where you intend to provide services be identified before you may submit your application for licensure. And by the same token, many clinical practices, hospitals, agencies, and other community stakeholders require or prefer that you have a license before you can be hired. So essentially you need a job to get a license, but you need a license to get a job. Applying for work from out of state, lacking knowledge of mental health systems in new states, and lacking a professional network can be challenges for military spouses who are seeking to transfer their licenses in the course of a military move. I will say that once you're in a state system, it can become easier to navigate license upgrades or to seek new employment. But I think it's a really challenging process to originate licensure in a state. And that's something that military spouses of active duty personnel must do repeatedly. If you'll move to the next slide, please. So there are some systemic implications for counselors and military spouses who are experiencing barriers to license transportability. Military spouse underemployment and unemployment are systemic issues that legislators who are in this summit are likely familiar with. Before COVID, a 2019 DoD survey found that military spouses faced a 22% unemployment rate. And to put that into perspective, the Bureau of Labor and Statistics recorded a 2019 unemployment rate in all of the US at 3.5%. So that's an 18.5% difference. The DoD also found that military spouses experienced a 26% wage gap compared to their civilian counterparts. As many as 34% of military spouses hold professional licenses, and 1 in 5 reported waiting 10 or more months for their licensing credentials to transfer between states after a move. So the barriers of obtaining licenses to practice in new states are compounded for military spouses who move on average every 2 to 3 years and cross state lines 10 times more often than average American families. So I graduated with my master's and I began clinical practice in Colorado while my family was stationed at Fort Carson. Next, my partner received orders to Fort Benning, Georgia, where I spent 6 months unsuccessfully seeking licensure and a job. Next, the Army moved my family to Fort Hood, Texas. I applied to numerous jobs and was ultimately contracted to work part-time for a community practice. And that was a really rare opportunity, which actually allowed me to be hired before I submitted my application for licensure in the state. Over time, I picked up 2 part-time volunteer counseling positions, one at Fort Hood and one at a domestic violence shelter in the surrounding Killeen, Texas area. So across 3 states and in 4 years, I finally earned my independent license in Texas by cobbling together a variety of paid as well as volunteer clinical placements. But I did that because I was really determined to make the most of the clinical opportunities that I had available to me so that my future career transitions would be facilitated by my efforts to gain experience and to be fully licensed. Despite having earned my doctorate and license at the time that my family moved from Texas to the East Coast for another military assignment, I still fell short of having enough consecutive years of experience post-licensure to transfer my license to our new state. So cumulatively, these experiences have created financial and career hardships as I've tried to pay back my student loans and grow my career. As a military spouse, my experience is that I'm frequently the newest person on a staff. I have a finite period of time to develop my skills and my expertise and to build a professional network, and ultimately ensure that in 6 months or in 2 years, I have the skills and experience that I need to quickly find a job and transfer my license to our next duty station. That's really important to me because I grew up poor. I grew up in a single parent household, and I'm a first-generation college student. I'm really committed to building a financially secure life for my family, and long periods of under or unemployment with each military transition because of license reciprocity issues are really concerning to me personally and professionally. And I'm really proud to represent some of those identities in the space of counseling. And so I'm hopeful that this licensing compact can be something that ensures that groups who may struggle with their professional careers have a little bit of greater ease of navigating the professional world. So I appreciate your intention and understanding as I described some of those direct struggles that military spouses can experience transferring their license from state to state. But another consideration that I want to suggest is that the counseling compact may have implications for mental health care access for military populations. So active duty, reserve, and guard personnel, veterans, their spouses, and children are all at an increased risk for mental health concerns. So the high-risk nature of military service and frequent transitions related to deployment and relocation represent risk factors for wellness among members of the military community. Yet mental health services actually appear to be underutilized by military populations. Findings in a consensus study report to evaluate the Department of Veterans Affairs mental health services estimated that as many as 41% of post 9/11 veterans have a mental health need, but that more than 55% of those who are in need are not receiving mental health services of any kind. And among service members who do access care, only about 50% complete treatment. Among military spouses and children, rates of mental health need exceed rates of mental health care access. So as a counselor and member of the military community, there's a nuance here that adds complexity to what constitutes mental health need, and that has implications for rates of access to mental health care. There is much more to well-being than the presence or the lack of measurable symptoms. I teach my students that a reduction in intrusive memories or the elimination of flashbacks are our duty as mental health providers, but that these don't reflect the totality of our work. Our clients also deserve to improve the quality of their relationships, to feel connected to their communities, to feel joy, and to find meaning in their lives. And it's really important not to reduce our estimates of mental health need to rates of diagnosed conditions, and to acknowledge that mental health need is likely underestimated and underreported. So within military populations, there are a few important barriers to seeking mental health for us to consider. So some are systemic, right? We need to answer questions like, do military populations know what mental health resources are available, both connected to the VA and the DoD, or through TRICARE, private pay, or other resources in their own communities? Then how are services accessed? Where are services provided? How far away is the clinic? What kinds of fees are involved? There are also more intrapersonal barriers to accessing care. So what attitudes do military populations have about mental health? What perceptions do they have about mental health care providers? How might mental health impact military service eligibility? So stigma plays an important role in the identification of wellness concerns and military community members' willingness to access mental health supports. In a Surgeon General report about the underutilization of mental health care in the US, researchers actually suggested that addressing systemic and logistic barriers to accessing care can actually mediate the interpersonal barriers like stigma or mistrust. So by improving the accessibility and the visibility of culturally responsive mental health care among military populations, we can actually improve engagement. Military culture is characterized by mission first mentality. So it reflects core values of resilience, mental toughness, adaptability, and sacrifice. The counseling compact may actually represent one way to ensure that military spouse clinicians are able to address mental health disparities in their own communities. So by reducing barriers to licensure and employment for military spouses, my hope is that service members, their spouses, and children have access to an increased number of counselors in diverse settings, and that there's an increased visibility of clinicians who are knowledgeable and integrative of military culture in their clinical practice. So in my own clinical experience, a significant portion of my caseload has always included military families who have shared with me that the only reason they decided to request an appointment was because that they read that I'm a military spouse and they thought I would get it. And so while I believe there are many qualified clinicians who can serve military families, I'm really grateful for engagement promoting factors like shared experience or visibility. Lastly, I think it's important for licensed professional counselors to have a voice and a presence in serving military populations. Professional counselors' identity is grounded in philosophical values for prevention, development, wellness, and empowerment, which align with militaristic values that foster resilience, promote readiness, and reduce harm across developmental cycles of deployment and relocation. So counselors' strengths-based and relational foundations can contribute to culturally responsive perspectives that address holistic well-being in military communities. So as I conclude my thoughts today, I just want to acknowledge the Joining Forces initiative that was championed by Michelle Obama and Dr. Jill Biden during the Obama administration. Their advocacy for military spouses limited the length of time it takes for licensure applications to be processed once submitted. So just as Joining Forces effectively saves military spouses countless months of waiting and unemployment during interstate moves on military orders, I hope that the Counseling Compact can facilitate licensure portability among qualified individuals. And if anyone has any questions for me, I'd be happy to answer.
Thank you so much, Dr. Bergen, for that. Really speaking for everyone, informative and honestly quite touching and moving. A bit of advocacy for military families. And if you have any questions for Dr. Bergen, please put them in the chat or feel free to turn your mic on and chime in at your leisure. All right, seeing no questions, and move on to our next panelist. So now we get to hear from Dr. Kevin Doyle, who is the president of the American Association of State Counseling Boards. About Kevin, he's the dean of the Hazelden Betty Ford Graduate School of Addiction Studies in Center City, Minnesota. Professional counselor and substance abuse treatment practitioner in Virginia, and has served 4 terms on the Virginia chair, as well as 2 terms on the Virginia Board of Health Professions. He currently serves as president of the American Association of State Counseling Boards, and recently completed his term as the senior co-chair of the Ethics Committee of the American Counseling Association. Dr. Doyle, welcome, and thank you for joining us.
Thanks, Andrew. And I'm going to assume everyone can hear me okay. You were just slightly in and out there, but I heard you pretty well. So I'm assuming you're hearing me okay. Somebody chat with me if that's not the case. So yes, as Andrew said, my name is Kevin Doyle. I'm coming to you from Minnesota. Recently relocated here for this role, but have a strong presence in Virginia as well, and have over the years. And really happy to be with everyone today. I'm speaking today on behalf of AASCB. I may throw in a few of my own comments too, and I'll try to indicate when I'm doing that. But primarily want to speak from the perspective of the American Association of State Counseling Boards. And let me just say briefly what that is. A number of years ago, I think several decades ago now, there was a recognition that it would be important for the different licensing boards in the states and also territories, not just the 50 states, but DC and Puerto Rico and Guam and Virgin Islands, et cetera, to come together and talk about best practices from a counseling board perspective. And one of the hot topics over the years has certainly been the question of how does a licensed counselor move from state to state and continue to practice? And I'm sure that previous speakers have touched upon that from various perspectives. And I don't think it's unfair to say that we have, as a profession, not been really successful in that endeavor. There have been a number of different models that have been proposed by AASCB and other organizations, and to this point, nothing has really stuck very well, and there are real barriers from moving to state. So AASCB is very invested in trying to promote best practices in discipline, in board member orientation, and board member recruitment, continuing education, and a lot of other issues that relate to safe and ethical practice and regulation of counselors. But ultimately, a lot of our attention ends up coming back to this question of portability or reciprocity. In other words, the ability of a counselor to move from one state to another and continue to practice. So when the compact emerged, we were obviously very interested in what it would look like. Sorry, my screen just changed a little bit. What the compact would look like, what the contents would consist of, and what our role might be in helping it to be successful if it was something that we felt comfortable with. AASCB had representation on the initial drafting committee. My predecessor, Ryan Pickett, who's our current past president, participated on the drafting committee. We participated in the listening sessions that were held when the early versions of the compact, or the initial version of the compact language, was rolled out, offered our input there. And ultimately, this past winter and spring timeframe, we did vote as a board to support the compact in general terms. We didn't get bogged down in the precise details and the precise language, but because I think we felt that our role was to encourage this process to continue. And of course, the process is not final yet either. So we have posted, and it's on the Counseling Compact website, I believe, a letter of support for the compact going forward. I think what that represents is our endorsement conceptually of the idea that using the model of a compact is the correct way to proceed, that relying on individual states or member boards really to, sorry, I just moved my cheat sheet here, to make agreements with one another is very cumbersome, and to try to keep up with the individual state regulations is also unwieldy. And also, sometimes the model previously had been a group would propose sample language for licensure and then hope that lots of states would endorse that language. But as many of you know who are on this gathering today, the regulatory process is a very slow and cumbersome one, state by state. And so reversing the order here of asking states to sign on to something that exists seems a much more efficient way of approaching this. And I'm trying to summarize the general conversation that AASCB had in making the decision to go forward. At the end of the day, I think we came to the realization that a more efficient method for counselors to move from state to state was long overdue. We sense a groundswell in our profession of dissatisfaction among people, whether it be, as the previous speaker indicated, military families, spouses or military members of the military specifically, or just people who are well established in their careers and move for whatever reason. And I think a dissatisfaction that why is counseling different? Why is this easier for members of other professions to do? And we felt like it was important for us to endorse this process for that reason, as long as we felt comfortable what's in the content. At the end of the day as well, I think that what has been said by other stakeholders here, including ACA, is that it is important for licensing boards to trust other licensing boards. I see that our president-elect Alva Robinson has joined us, and a number of us were recently, this last week actually, at a gathering of regulatory boards in Denver. And when you talk with professionals from around the country and hear about what their licensing boards are doing, I think it instills confidence in you that state licensing boards are not licensing incompetent, unqualified counselors. Are our regulations identical? No. But can we trust other licensing boards to be vigilant around who is licensed in those states? And this is where I may be venturing a little bit into speaking for myself, but I think in general, AASCB would endorse this. Yes, we can trust other states to be diligent and vigilant and careful and cautious about who is licensed in those states. The compact does not mandate identical licensing standards, just that each state meets the minimum that is dictated in the compact language. Finally, we also trust that the commission, that if this were to go forward, would then be formed to form the final rules, would have a final opportunity to look at any tweaks that need to be made to the final compact language. That's our understanding of how the process works for a compact. And so we trust that process too, and we trust our colleagues who would be part of the commission developing the final rules. And so ultimately, I think all those factors contributed to AASCB feeling comfortable, and not just comfortable, but confident that a compact such as what has been proposed is the correct way to proceed, and that we should be supportive of that. So I decided just to share remarks verbally today, rather than go with death with PowerPoint. And when I looked at the quality of my predecessor's slides, I'm glad I did that, because those were very high quality slides, and really felt as if I just wanted to share our impressions and our perspective with you verbally. So I hope I've done a good job of representing AASCB's position on this, and I'd be very happy to respond to any questions or comments that anyone might have.
Thanks so much, Dr. Doyle, for that of AASCB's position on the compact. Any questions for Dr. Doyle? Or feel free to chime in verbally if you prefer. And while you're thinking, I would clarify one point, which is that majority of the commission that's the actual final terms of the compact. That's all enacted in the statute. They're able to make rules to implement the compact things that may have been left up to the commission by the compact. So the rest assured that whatever is enacted is the same in your state. There are no changes to the language. Any questions for Dr. Doyle? Well, seeing none, thanks so much, Dr. Doyle, once again for joining us and that excellent presentation. And now we can move on to our final panelists as I reshare my screen. Does that look good to everyone? Okay. So we're now joined by Mr. Jake Whitaker, who is the Deputy Legislative Officer in the Office of Governor Larry Hogan to Counseling Compact in Maryland. Jake graduated from 2014 with a BA in History and graduated from the University in 2017. Of Governmental Affairs at the Maryland Department of Health from 2017 to 2020. Currently, the Deputy Legislative Officer with the Office of Maryland Governor Larry Hogan. Jake, thanks again for joining us.
Thank you, Andrew. I appreciate it. I don't know if everyone can hear me. I was cutting out for a second. As Andrew mentioned, I'm the Deputy Legislative Officer for Governor Larry Hogan at Maryland. Since taking office, Governor Hogan and Lieutenant Governor Rutherford have remained committed to expanding access to critical behavioral health and substance use disorder treatment services. As many here know, the COVID-19 pandemic has only exacerbated the need for these critical treatment services. Drug overdose deaths in Maryland and across the United States have increased since the beginning of the pandemic. And in keeping with the Governor and Lieutenant Governor's commitments to reducing these barriers to critical behavioral health services, we thought the Counseling Compact was an important step to increasing access to service and care for Maryland patients and other states. According to data from our Maryland Medicaid program and the Behavioral Health Administration, the number of people who access mental health services increased dramatically from 2019 to 2020. For example, in 2019, there was about 7,300 folks that reached out for mental health services, and that increased over 100,000 in 2020. So as you can see, it's going to be incredibly important to reduce barriers to care and make sure that these services are available for individuals who need it. What kind of began our steps towards ultimately endorsing and advancing the Counseling Compact was Lieutenant Governor's leadership and chairing of the Maryland Mental Health Commission. The commission is comprised of members of the Maryland General Assembly, state health officials, mental health experts across the state, and members of the public. In the commission's 2021 report, the members recognized the importance of increasing access to behavioral health services, and this included increasing access to counseling services. There was three kind of key stakeholder groups that we worked with in advancing this legislation and ultimately passing it. The first was the Board of Professional Counselors. The other was state associations like the Council of State Governments and the American Counseling Association, and ultimately legislators. So we worked with the Board of Professional Counselors before introducing the legislation to make sure that any of their concerns or questions were addressed. I think, and gratefully, the board recognized the importance of having an interstate compact and reducing these barriers to licensure in other states. Specifically, I think the board was pleased to know that this legislation preserved their authority in Maryland to protect public health and safety through existing state and regulatory structures. I think importantly, and the board recognized this, was that unlike national licensure legislation that supersede their state regulatory authority, an interstate compact like the Counseling Compact allows member states to continue to determine the requirements for licensure. Fortunately, we worked with the Board of Professional Counselors, and they ultimately overwhelmingly support this legislation. And I think that was critical to advancing and ultimately passing it. As I mentioned, we also worked with key state and national stakeholder groups. So for example, the American Counseling Association was very helpful in advancing this, as well as local groups like the Maryland Hospital Association and other behavioral health provider groups. In fact, we saw very strong support from the provider community to the point that one of the providers reached out to us and asked if we could make this emergency legislation, so that as soon as it went into effect and as soon as we got that critical mass of 10 states signing on to this, we were able to advance this legislation. So because it was an emergency bill and ultimately passed unanimously, the second the governor signed the bill, this became effective law in And then I think most critically, we met with legislators across the state. I think what really helped us advance this legislation was meeting with the key committee chairs as well as committee members in the health committees in both the House and the Senate. I just really wanted to make sure I had an opportunity to meet with most of them individually to answer any of their questions and speak at length with them about this legislation, how it can help Marylanders, and it doesn't usurp the board's authority to protect Maryland patients and licensees. And I think that was really helpful because we did get some questions during the hearing, but ultimately I think it was very helpful, and I think there were very few, if I recall correctly, if any at all, because we were able to meet with them and address those concerns. So most of the key committee members really understood this legislation, and I think that's what helped us advance it so quickly. And as I mentioned, because of the work, most importantly, with the stakeholder groups and the board and the General Assembly, the legislation passed unanimously, including the emergency amendment in both the House and the Senate. So as I mentioned, I think this legislation is critically important for increasing continuity of care, reducing barriers to access to treatment for Marylanders and other folks in other states. I think it's also critically important in Maryland because a lot of folks are traveling across state lines to DC or Virginia, and they either work in DC or work in Maryland and travel across on a daily basis. So I think this just helps kind of reduce those barriers for folks that may have had trouble getting services from Maryland ICNCs or vice versa. So in keeping with the governor and lieutenant governor's commitment to reducing these barriers, I think this compact resulted in a much needed increase in the number of professional counselors in Maryland. It's still early in the process as you know, we still need that critical mass of 10 states. But I think once we do, this legislation is going to be great in increasing the availability of counselors to Marylanders, and then in turn other states who join the compact. So just in closing, I want to thank the Council of State Governments for putting this together. I think it's with meetings like this that will help kind of answer the questions for states that are considering advancing this, and to increase, and as we increase the number of states participating in the compact, it'll only make the compact that more effective and increase the number of counselors available to everybody. And then specifically, I want to thank Andrew for organizing this meeting and his help the last couple of weeks, and I'd be happy to answer any questions.
Jake, for that excellent explanation of the kind of reasons why Maryland has been interested in these licensure compacts. A couple of panelists from the DC, Maryland, Virginia, DMV area, as that is, really one of the central locations in America. Other areas like, Kansas and Missouri, for example, that have a lot of interstate practitioners, is really ground zero for issues with license portability in the professions. So it's great to have that perspective on board. If there are any questions for Jake, I will have another awkward pause. And if you'd like to put something in the chat or turn your mic on, feel free. Privately in the chat for Jake, which is what did you encounter to the compact? And
Apologies, Andrew, it cut out for a bit. Do you mind repeating the question?
All right, I'll go off. So we had a question about opposition that you might have encountered when carrying the compact, and how did you address that?
Well, fortunately, in this, as you might imagine, isn't always the case with a lot of legislation. We pretty much had wide stakeholder and bipartisan support for this legislation. I think the COVID-19 pandemic made it really clear that there's going to be an increased demand for mental health and behavioral health services, as well as the fact that this just reduces the barriers. It doesn't usurp the authority of the board. So I think some of the questions, and I saw on some of the other compact legislation that was moving forward in the General Assembly, was whether or not this usurps the authority of the board. So I think we want to make it very clear to any stakeholders and to reach, for states that are considering advancing this legislation, to reach out to the relevant licensing board so that they're aware that, look, this allows for folks to be able to practice across state lines, but it doesn't eliminate the board's authority to make sure that they maintain a specific scope of practice. So I think that's the biggest barrier, but I think it can be addressed, before you battle out in a committee hearing or something like that.
Thanks. I would echo what Jake said about consulting with affected state boards. That for the vast majority of states, there's likely another board that is already participating in a compact, and they can provide a lot of context as to any added costs or added administration that accompanies the compact, as well as as Jake said, the preservation of state licensing requirements and state licensing authority. It's always great to just have a chat with your fellow boards who are already. Any other questions for Jake? All right. Well, I would ask any panelists to remain on the line for just a couple more minutes. Time for question and answer, as we've been pretty much on schedule here. So at this point, questions for all of our panelists. I see Jake still, Elizabeth, Nahali's still here, and I believe Dan is still on the line as well. And we've got a lot of very smart people on the call who can chime in and answer questions as well, including folks from ACA. So at this point, if there are any questions for the panel, so I did receive a question a while back that I was holding for the end. That's regarding who can serve as a commissioner on the Council and Compact Commission. And I can actually take that one myself. It's essentially a board member or a board staff member, which would be a board administrator / secretary. And then, as Nahali sort of already covered, there are, of course, states that don't have a typical licensing board regulatory structure. And for those states, it's someone who's a member of the staff for that specific licensing agency that handles a fairly wide variety of folks who are eligible to serve as commissioners. And it doesn't have to be necessarily a member of the profession. It can just be a public member of the licensing board or a board administrator as well. And then another question that I got privately in the chat was, and I think Nahali might want to take this one. It was asking for a little bit more specific information about what the process is for standing up the Interstate Commission, which we are currently going through with the Audiology and Speech Compact. So Nahali, do you want to take that one?
Certainly, Andrew. So to convene the commission, we first sent out a solicitation for designation of commissioners, and each state, of course, chooses their commissioner. And we have a form where there's a letter that vests appropriate authority in the appointing officer, agency, et cetera, to seat the commissioner who will have full voting authority on behalf of the state. We then convene a meeting, and at that meeting, the commissioners come together from all of the current member states, and we immediately begin adopting additional bylaws. There are some bylaws already embedded in the compact, but additional bylaws that are needed for the administration and governance of the commission. We start setting about triaging rules that are important, that will be the most immediately needed rules for, again, administering the compact. And again, both of these things have to be fully authorized and tied to the actual law. For instance, with SIPAC, I think over the course of about 2 days, we adopted quite a bit of bylaws. We seated an executive committee because you need an executive committee in place So we seated an executive committee. We had a committee of committees because when you're first starting out, you don't really have enough participants just yet to seat multiple individual committees. So we created a committee of the committees to do the work of the commission. We adopted a number of rules, including things like how the database system would work. We considered a contract for a secretariat services. And that was a full commission voting matter, was who would serve as secretariat of the compact, and with a thorough review of that contract and agreement by the full commission. We considered a IT contract for the database system, and basically all the most crucial things. Oh, and importantly, we determined what our expectation was with regard to member states' implementation, actually issuing the privileges. And as I've mentioned multiple times in the presentation, that takes a while. It doesn't happen overnight because there's quite a bit to be done, and you want to do it correctly. So we set out some time limits on that. And I don't think it was even until the next meeting, a couple of months later, that we considered what the fees would be. I don't even think we took that up initially. So that's sort of what the initial standing up meeting is. You got to get your commissioners around the table. You got to get enough bylaws to where you can really do what you need to do, all again directly tied to the law and authorized clearly by the law. Rules that will help the very initial stages of the commission. For instance, the Nurse Licensure Compact Commission, they have a standing committee, of course, for rules, and their rules are constantly being revised, or new rules being promulgated, or rules going away, just like with your board work. You need to constantly be reviewing your rules and make sure that they're timely and that they're in keeping with only what you need to govern. So that's sort of what it looks like. And I don't know if that answered the question fully enough, but usually the initial meeting is about a 2-day process, and folks get elected and contracts get voted on, and rules get triaged.
To follow up to that, a frequent question that we get from licensing boards who are considering compacts is, I guess, after that sort of initial phase of setup, what's the workload like for the commissioners from that? Can they expect to meet? How long do meetings typically run? Are they virtual, in person? Just that sort of thing.
I can respond to that, but if Dan's still on the call, he might be slightly better to respond to that. But if he's not, I can certainly be responsive. Dan, are you on?
I think Dan.
Okay, so I can speak to it then. The additional workload, and that is a fear. We have that fear with one of the current compacts, and I think until things settle down and we have a better trajectory of where we're going with the Delta variant, that most compacts can assume that there'll be a hybrid model of meeting. I don't think there's a single compact that has a requirement of in-person attendance. Can't think of not to my knowledge. So you have to attend and participate, as you have to with your own boards back in your states. Obviously, part of good governance and your duty of good faith and loyalty is to participate and to be knowledgeable about your governing documents. So you have to participate, but I don't believe there's any requirement that you participate in person. I do think that most commissions have minimally you have an annual meeting. Usually there's a mid-year meeting of the full commission. Committees meet more frequently. So in the infancy of a commission, you will have to meet more necessarily because there aren't enough people yet to seat all of the committees. So I think that the workload could be, you could see yourself involved in a rules planning call maybe once a month. I don't know any of these commissions that are meeting weekly, even in committee form. That there's no expectation of that. I think some of the more active committees like rules probably meet once a month virtually to discuss things. Sometimes if the agenda is kind of short, they can push that off. But I think that you're talking about, I always say the best way to answer questions like that is to call another profession that already has a compact in your state and ask their administrator, what kind of time are you putting in? Because I can speak to it all day long, but the best folks to go to would be someone else in your state who has already enacted a compact, be it physical therapy, nursing, medicine, EMS. Call those folks and SIPAC, call those folks and say, how much time are you really putting in? And that's really your best way to get to the heart of that. But I don't know of any compact yet where someone has said, I just can't participate because it's too much work. Sometimes people can't participate because they move on to a different job or they have personal issues, but I haven't heard anyone as of yet say I can't participate because the workload is way more than I thought it would be.
So great informative response, Holly. Thank you. I did get a question from Bill Green that I thought might be worth highlighting. He asks, because of the turnover words, whether there would be an option for former board members to serve as commissioners. And I mean, I would say probably that's pretty dicey territory because it would no longer be an official agent of the state. But I guess I would ask Nahali, is there any opportunity for a state to say an ex-board member as an official agent of the board, and that person could then serve for a longer period of time?
Well, and I heard most of that, but I will say I think we're pretty much on the same page. My concern as potential legal counsel to a commission would be you have to have your immunity travel with you, and if you're not currently a state actor by virtue of your authorized position on a state board or the group that regulates the profession, then I would be worried about what sort of immunity you do have. So for that and multiple other reasons, most of which is the language of the compact, we don't suggest that former board members serve. That question always comes up though, and for obvious reasons, because former board members sometimes are retired and they have the institutional knowledge and a little more time. But unfortunately, that issue of immunity transfer, that makes that of greater concern. And of course, we don't ever want to get in a situation where the person who has been seated as a commissioner and placed there by the state doesn't have full authority on behalf of the state. So most AGs would take issue with that if it was someone who wasn't currently serving a state board or a similar organization or agency rather.
Yeah, that's what I figured was the case. I guess I would note that a state, there's nothing stopping a state necessarily making a law to designate a longer serving member of a licensure board, but that would be very much up to the state and not something that the commission could do for the state.
And the state, and just let me clarify, and the state would need to look to the compact language. I mean, if that, and this varies between compacts, I'm sorry, I'm not looking at the section right now, but this varies from compact to compact, but it can't be in violation of the requirements that each compact sets out for a commissioner. So if it's impractical, if it's, there's a legal term called impossibility. If it's, a legal impossibility or a legal impracticability for the person that we designate in the language of the compact to serve, then we deem that not to be substantive enough to not allow the state to appoint someone else. So there are instances, there are very few though. So that is, I don't want to misrepresent that in any way. You want to try to stay, with the language with regard to the requirements for the commissioner that you appoint. But if there's something that really is getting close to legal impossibility to fulfill, to seat that person, then that's something that we would talk about. And we're actually having to do that with a couple of states. With the speech language pathology and audiology compacts. So it can come up and we work through it, but bright line rule, you need to seat the person that fulfills exactly what the language says.
And the language of the compact does licensing board or current employee. So yeah, as Nahali said, the likelihood of that coming up is fairly low, and states should definitely make all effort to seat someone who complies exactly with the terms of the compact. And then I have one more question. Sorry, someone's speaking. We did have one more question, which is about looking to the future. How soon can we expect this compact to be in effect, which is a 10-state threshold for activation. And while, of course, legislation is complicated and with a lot of states still meeting remotely and meeting on a limited basis, legislatures aren't functioning at max capacity currently. We are expecting within the next year or so to reach our 10-state threshold for activation.
As all the panelists have said, it's very timely. This profession has never been more crucial to the well-being of the public that we all serve than it is right now. So I agree with Andrew's soothsaying. I mean, it looks good, and many states have been very interested and responsive.
Absolutely. Well, if there are no other questions, and I will have one final comfortable pause to the surface. All right, seeing no additional questions. Well, I want to thank us one more time for joining us. We're not able to be here. We do have, Lee, which is asking, is there a possibility of more than 10 states? Technology and Speech Compact, we actually had 14 states enact prior to standing up the commission. So any state that enacts the compact language prior to the standing up of the commission paid in the standing up of the commission. So those additional 4 states that enacted the AASLP compact will be able to participate in rulemaking. So the answer quite simply is yes. Allowed a long enough pause, there would be another question. But seeing no additional questions, like I said, thanks again to all of our panelists for providing such a great summit. Thanks so much, everyone, for sticking it out for this 3+ hours of content. We hope that you found it informative and not overly. If there are any questions that didn't get to be asked, I will put my email address in the chat, abates@csg.org. That's abates@csg.org. Feel free to reach out. Thanks everyone so much for being here. And like I was about to say before I cut myself off, there is another session tomorrow. So if you missed part of this one, there's another session from 1 to 5 tomorrow. That's Eastern time. The invite registration link for that was included in the same invitation as the link for this session. But if you need the link to that second session, please reach out, shoot me an email. And I will also emphasize that we will be posting the recording after a couple of days of processing time to the CSG and Counseling Compact websites. And I will follow up with the link to that with all of our invitees. And we will post the slides along with that as well. And I would have finally emphasized, you do not need to come tomorrow if you have been here for the entire session. The agenda is the same. Same content, same panelists for the most part, and everything. But thanks so much, everyone, once again. And with that, I will give you back 45 minutes of your day. Thanks, everybody.